We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much, and good morning, everybody. Welcome to today's remote sitting of the Appeals Court. My name is Ariane Vuono. I'm joined today by Justice Sidney Hanlon and Justice Sukyoung Shin, and we will be the panel hearing your case today. Before I call the case officially, I have two brief reminders for you, and that is, excuse me, that the rules of appellate procedure pertaining to oral argument apply to arguments on a remote platform, just as if we were in the courtroom. So you each have 15 minutes to make your argument, and there is no rebuttal. Also, upon occasion, we experience a technical difficulty. If we do, please be patient. Generally, problems get resolved quite quickly, and we will resume. And you can be assured that you won't lose any of your time if we have a problem during the course of your argument. All right? So with that said, I'm going to call Commonwealth versus Kyle Spencer, 2020-0616, and we'll hear first from you, Attorney Murphy.
Good morning, and may it please the court. My name is Brian Murphy, and it is my honor to represent Kyle Spencer in this appeal. This is an appeal from the denial of a Rule 30 motion that was brought subsequent to a conviction at trial. The Rule 30 motion raises three issues. The first is prosecutorial misconduct in the opening and the closing. The second is the improper introduction of multiple first complaint witnesses. And the third is ineffective assistance of counsel. By way of introduction, I think it is important to acknowledge that this is a very close case on the evidence. There was one complaining witness. There was no corroborating evidence. There was no physical evidence. It is simply the testimony of one person alleging that they were assaulted with a lengthy delay before that initial disclosure was made.
Mr. Murphy, is it fair to say that that we're looking at all of this for substantial risk of a miscarriage of justice, right?
That is the case. I think the Safarian standard applies to the ineffective assistance of counsel claim, but I think it is the other two claims, yes, are turn on substantial risk of miscarriage of justice.
Okay.
As to the first claim, the claim of prosecutorial misconduct, I think it is important to first understand the nature of impaneling a jury in a case such as this. These are the most difficult cases to impanel. These are cases where jurors have a great deal of difficulty hearing the charge and then telling the court that they can be open and willing to judge the case on the merits. And what happened here is that this case was infected from the beginning until the end with an admonition by the prosecutor that they decide the case based on emotion and not based on the facts. It began with the prosecutor in his opening statement saying, do you remember that feeling that you had when you walked up the sidebar for individual voir dire? I want you to hold on to that feeling.
Why is that not, as the trial judge said, a call to remember the solemnity of the situation?
If that, in fact, was what the jurors perceived it to be, I would agree that it would not be problematic. But when you combine the statements made in the opening with the statements made in the closing, which is to go into the jury deliberation room, remembering the feeling that they had when all they knew was that this was a rape of child case. And knowing that these are cases where jurors voluntarily admit quite regularly that they cannot, that this is too emotional. Just hearing the charge itself renders them incapable of being.
Well, let me ask you, Attorney, there were no jurors that were seated that indicated they could not be impartial, right?
Correct.
Okay. And also, not only did the trial judge determine that the comment really simply reminded that the jurors that of the solemn oath that's being taken, et cetera, he also said that it was basically directed towards the jurors' common sense. That and we all know that it's a very typical argument and a typical charge to tell the jurors that they don't leave their common sense at the door. So can you tell us why you don't think it falls into that category?
So that is certainly the argument that the Commonwealth makes in its brief, that this is an appeal to common sense. And to support that argument, they point out that they mentioned common sense, a dozen times.
Yeah, but what do you say about that?
I say that that's simply not a fair reading of what they said. What they said was, and I won't belabor court by reading it again. It's been belabored enough in the briefs. But what was said in both the opening and closing was not an appeal to common sense. It was a blatant appeal to emotion. To say, remember how you felt walking up there, knowing that this was a rape of child case.
Did he say that? Did he say knowing that it was a rape of a child case?
He did not. No, he did not. What he said
That's
was,
the piece
Keep
of,
your feelings in your back pocket.
yes. But I raised that it's a rape of a child case because at that point, that's really all they knew. All the jury knew about this case was that what the charges were, and that they were going to sidebar to be examined on whether or not they could be impartial, knowing that it was a case of such seriousness, a case that engendered.
If I may interrupt you again. Let's say hypothetically, because of course the panel hasn't decided the case, that we agree that this should not have been said. Okay, that it was inartful and it was potentially misunderstood as an appeal to sympathy. But our view is still substantial risk of miscarriage of justice. So, and here we have a trial judge who has already said that he did not think, and he presided over the case, that was the case. So what can you what case can you point to, or what can you say to us that to persuade us, if you may, that this actually was such these two comments were such that the jury were so swayed that they returned a verdict that was unfair?
So I would say a couple of things. I think the trial judge acknowledged in the decision denying this portion of the motion for a new trial that these comments were, I believe his exact words were, inartful. And so he implicitly recognized, not implicitly, he explicitly recognized that these comments should not have been made. And when you combine it with the comments that the prosecutor made in the closing about how difficult it was for this person to testify at trial, about how they would never, why would they want to come up in front of a group of strangers and talk about the most intimate parts of their body and describe.
I understand that part of the argument is problematical, but how much of that is a fair response to the defense argument that this is all the product of a family feud?
I don't think that it is a response to that at all. And so we will get to whether or not the defense attorney properly raised any legitimate argument around the family feud. But putting that aside, it doesn't matter if even in a theoretical position where there are two competing narratives and the defense attorney says you should not believe the alleged victim because of X, Y, and Z.
But he gets to argue whether she has a motive to lie, right?
Yes, he definitely does. But that is not the same as saying she should be believed because she, as a young woman, got on the stand and described intimate parts of her body and described things that she claims to have gone through. That is not a proper argument, and that's not a proper rebuttal to a claim that she had a motive to lie or she was not telling the truth. It's just not permissible, even to rebut a claim that she was not telling the truth. And as the case.
What's your strongest case for that? By case, I mean something in the books, or in the law cases in Lexis.
Sure, I would point to Commonwealth v. Ribario, which is 49 Mass App Court 7, and it's telling that the victim appealing to sympathy and saying that testifying alone is a basis for someone to be believed, especially when, and it is important to look at this argument in its totality. When you talk about an argument that is based on emotion and is appealing to the difficulty of the case and the emotional gravity of even talking about something along these lines, and then you combine it with, and she had to get up there and testify about the parts of her body, about these allegations in a way that was embarrassing. I believe the direct quote was, she had to tell 12 strangers about these allegations. That is saying you should believe her because she's testifying. And the case law is replete with firm holdings that is not okay.
Counsel, could you clarify what you think the standard of review is? You started out your argument by saying this is an appeal from the new trial, denial the motion for new trial, but there is also a direct appeal. So on this issue, are we reviewing, I'm sorry, I'm getting some reverb here. Are we reviewing the judge's decision for abuse of discretion? or are we reviewing the claim de novo?
I believe you are, and I would concede that Mr. Zane was correct on this, that it is governed by Commonwealth v. Wentworth, that it is a significant error of law or other abuse of discretion. The ineffective assistance of counsel claim is, of course, the Safarian standard. But
Right,
the other,
but I mean, normally, or not normally, but often we see challenges to closing arguments raised on direct appeal, and there was a notice of appeal filed here from the convictions. So how does the decision on the motion for new trial factor into our standard of review?
I think the way that it factors in this instance is that since the new trial judge was the trial judge, that some deference is in terms of the significance of these missteps is warranted, and so I concede that that's the case.
There's no objection to anything in the opening or the closing, right?
Which is why I think to get to your question, Justice Shin, it doesn't matter because since it was unpreserved error anyway.
No, I understand that the way we would review prejudice for a substantial risk of injustice. My question is whether we're reviewing for abuse of discretion because this claim was already rejected by the judge on a motion for new trial. Whereas often is the case, we're getting these arguments on direct appeal, so we don't have anything from the trial judge to review. Do you understand my question?
I do, and I think that still leaves you in whether or not there was a substantial miscarriage of justice standard. And in this case, I think when looking at it collectively, and that's what we are required to do, is to look at all of the errors in the opening and closing as a group. And when looking at the tenor of the opening and the closing that began and ended with, remember the emotion you felt, knowing only that this was a rape of child case. Remember that she had to get on the stand and testify. And remember that she had to describe these things that happened to her to a group of strangers when she was only a young lady, a young woman. That collectively, it makes this so worrisome that we could not conclude with confidence that it did not sway the outcome in the case, and it did not result in the verdict that we have in front of us. I want to briefly, I recognize I'm short on time. I want to turn briefly to the ineffective assistance of counsel claim. And I think in this respect, it is closely related to the opening and the closing, because a failure to object to this opening and closing is clearly ineffective assistance of counsel. There is no reason not to. There's no tactical reason. There's no reason that would make any sense in terms of the case. And he failed to recognize, the trial counsel failed to recognize that these comments were problematic, and he failed to object to them. In addition, trial counsel failed to introduce, he failed to both object to the introduction of a second first complaint, which was done via direct examination by the prosecutor. A second first complaint was introduced. He did not object to it. Trial counsel then compounded the error by further introducing additional complainants.
But it wasn't his argument that these are prior inconsistent statements?
That could have been his argument if he had elicited that they were inconsistent, but he didn't. And in the case of he asked about her speaking to the guidance counselor, adding that additional complaint.
And wasn't his point to rebut the thing that you were just arguing, that she was talking about it to all kinds of people, including adults? So why is it such a big deal? Why should you assume anything about her credibility? Because I think I'm getting some feedback, but I think I made the point. So
I don't think that there's any strategic benefit to him eliciting. So there are two additional complaints that were, one came out on direct, and then one was further clarified on cross-examination. And trial counsel asked on cross-examination, who were the other girls you told at the playground? To which he received an answer, these couple of people. I see no strategic advantage of that. I can't.
What do we do about the fact that trial counsel here submitted an affidavit, but the affidavit doesn't address this particular claim? So how do we know it was not a strategic reason?
I think we can review the transcript and conclude that there is no conceivable strategic reason. What would be the strategic reason for introducing the names of additional complainants where there's no inconsistency, where it was given contemporaneously with the first complaint, where we don't know the
But there were inconsistencies between the initial first
Mhm.
complaint and the same report and the, I think there wasn't there a 58A hearing? I mean, there,
72, yes.
and he did argue that, and you might have, in retrospect, sorry about but anyway, I shouldn't argue with you. Go ahead.
I think the main thing, and I'll use my last couple of minutes to briefly mention, is that the theory of defense here was that there was family discord. The court said you can introduce 3 instances of family discord. The trial counsel simply, I guess, forgot about the third one. The second one that they tried to introduce, the Mother's Day event, he had not interviewed his own witness, who he put on the stand in the hopes of eliciting evidence of this family discord. And she said, I don't think that, wasn't there. I don't know what happened. There's no strategic advantage in not preparing your own witnesses and not knowing that they will in fact deny the thrust of your defense. I recognize that my time is up. I will happy to address any further questions, but I would otherwise rest on my brief.
All right, well, thank you for your argument. I'm going to check with the panel to be sure that there's no additional follow-up questions that either have. No, I see none. Thank you very much. We'll turn now to Attorney Zane.
Good morning, Your Honors.
Good morning.
And thank you very much for your time and consideration. The first point that I wanted to address, and it's how we start off both of our briefs, is the opening statement. And as the court in its questions correctly pointed out, there were no objections at any point during the opening statement, either during or after, nor was there a request or a sidebar for any sort of curative instructions. Additionally, during the trial, there was no flagging of it coming back up in closing argument. And as I point out in my brief, and is reflected in the transcript, defense counsel also refers to the impanelment process during his argument. I realize that I'm standing here arguing on the words that I said, but I am also trying to be objective, but it's hard. But I recognize that the court, when we had the motion for new trial, he characterized my words during opening statement as being inartful. I can tell the court that if I had made any reference to the fact that this was a rape of child case and that should be a part of what you keep in your back pocket, I wouldn't be here making an argument in front of all of you. That would have been improper, and that certainly would have relied on sympathy and emotion. My point, and as the judge said, it was inartful and maybe it was lost. But my point was that you're going to hear, this is a case that's going to come down to one witness, the victim in this case, and that she's going to be coming into a formal setting. Not only that, but you're going to have to hear statements that she made in additional formal statements. As the court pointed out, there was a 72A hearing. Additionally, there's a SANE recording where she's in a room downstairs being recorded by unknown people. So my point, my purpose, and again,
I'm going to interrupt you just for a second, because I just want to help you out and make it clear that we look at the transcript and what was said at the transcript. And so I appreciate the fact that you're talking about your own words here, but what your point is and what you were thinking, what you were doing is sort of as outside the record, and not something that we can consider whether or not it was inartful or if it was proper or if the defense attorney should have objected to it. So that's the lens in which we're going to be reviewing this particular issue.
Thank you, Your Honor. As you can probably tell, I haven't been before this court many times. But no, as the court said, this is the standard of review is a substantial miscarriage of justice. Here, the trial judge, he pointed out that this was fleeting, and I would characterize it as abstract, in that the majority of the opening statement consisted of anticipated testimony from the witnesses. I'd say it was not.
What about the fairly lengthy paragraphs spanning the record appendix from 847 to 849 that defense counsel highlights? Isn't that argument fairly taken as you should believe the witness because she came in and testified?
I think the transcript would reflect, Your Honor, that that's more of a rebuttal to defense counsel, trial counsel's argument that he stressed over and over again that this was going to come down to credibility. I would say that the transcript reflects that the majority of the closing statement made by the prosecutor myself was a rebuttal to a bias or motive
What
to
about
lie.
that? What about that specific portion of the closing? You know, it says, why would she come in here and face you and stand, you know, sit 7 feet away and be subject to, you know, these very private questions for days? How is that really implying anything other than believe her because she came in here and testified in front of you?
I would agree that portions of that were inappropriate. But again, with the standard of review being a substantial miscarriage of justice, I think looking at the context of the majority of the closing argument, 90 to 95% of it was appropriate, was a fair response to rebuttals. I think the transcript and an inference that can be drawn from it is that it's hard to separate from, it's hard to, looking at it in the entire context of the closing argument. When you take just that section, it does sound inappropriate, looks inappropriate. But defense counsel, I know that there was one point in his closing argument during cross-examination that he points out that the way that she talked, the definitions that she used for her body parts wasn't appropriate. And there, I think that statement, certainly in the whole context, goes back to the jury's role to assess her credibility. So again, it's just stressing, look at her, you watched her, you heard her, whatever decision you make in those deliberations, it's going to come from her testimony, not what I say, not what anybody else said, what she said. So that would be my response to the court. As far as the ineffective assistance of counsel argument, Attorney Doherty, the trial counsel, supplied the court with an affidavit that makes it clear that he was prepared for this case, that he went as far as to meet with witnesses, went to the scene of the alleged rape, talked with family members, and the people that he failed to call. Well, he didn't fail to call. He made a strategic decision because he found that the witnesses that defendant is now saying should have been called were not credible. So certainly as a prepared trial counsel, he's not going to call them. Specifically, one that comes to mind is Richard Lunin, a friend of the defendant. He said that he determined he was a character witness, which is certainly reflected in the 72A transcript. I think he went as far as in that hearing saying that he'd give his life for the defendant. So here, the steps that Attorney Doherty made and took in this trial were strategic, and that goes back to the first, as far as the cross-examination of the victim, and when she gives the additional names of additional people that she told. The transcript reflects that was entirely a strategic decision to undercut the Commonwealth's argument that this victim had a hard time expressing what had occurred to her. She found it very hard to talk about these crimes. I mean, that was certainly present in the opening statement and in her testimony and direct examination. And there, that strategic decision undercuts all of that by saying, well, wait, this is a delayed disclosure case. This is hard for you to talk about it. But as one of the honors pointed out, she's out in a schoolyard, I believe, or outside talking to other friends, which entirely undercuts the Commonwealth's argument. So I think that, along with the cross-examination of the victim, where she ultimately at one point says, listen, if you say that I said that in the 72A hearing, I'm going to agree with you. She essentially adopts defense counsel, trial counsel's cross-examination questions without even letting him finish. So these were strategic decisions, and that's certainly contained and reflected in the transcript. I'm not sure if the court has any additional questions. I'm happy to answer them, but at this point, I'd rest on my brief.
Okay, thank you. I'm going to check with the panel and see if they have any follow-up questions for you. I see none from Mrs. Hanlon, and I see none from, I believe, none from Mrs. Shin. Okay, so thank you both very much for your arguments. Thank you for your briefs. The briefs are well done. The arguments were very helpful. We'll take the case under advisement, and we'll get an answer to you as soon as possible.
Thank you very much, Your Honors. Have a nice day.
We're live.
Okay, thank you very much. And good morning and welcome to today's remote sitting of the appeals court. My name is Ariane Vuono. I'm joined today by Justice Sydney Hanlon and Justice Suk-Young Shin. Before I call the case officially, I have two quick reminders for you, and that is the rules of appellate procedure that pertain to oral argument in the courtroom apply to a remote sitting equally, so that therefore you each have 15 minutes to make your argument and there is no rebuttal. And second, upon occasion, we have a little bit of technical difficulty. Please be patient if that occurs. Usually any issues resolved fairly quickly, and I can assure you both that you will not lose any of your time if something happens during the course of your argument, okay? So with that said, I'm going to call the case Commonwealth versus Thomas Benjamin, 2020-0478, and we will hear first from Attorney Griffin.
Good morning, Your Honors. May it please the court. My name is Geraldine Griffin. I represent Thomas Benjamin. There are several issues on appeal, Your Honors, but I'd like to focus on the first issue, which is the denial of the motion for new trial based on ineffective assistance of counsel. Your Honors, this was a difficult case for the defense. As you are aware, the defendant had admitted to being involved in the incident, in the fight, and the Commonwealth presented two very credible, objective eyewitnesses who had seen the fight. Under the circumstances, the defense attorney, for unknown reasons, seems to have chosen to select to argue misidentification as his primary defense. Now, it's not that apparent from the cross-examination that he did, because he didn't do very much cross-examination during the trial. But if you look at the opening and you look at the closing, he's trying to argue misidentification. And my argument on appeal is that this was really unreasonable, given the amount of
Let me just ask you a question, if I may. Our time is short, so excuse me for interrupting you. But when you say it is unreasonable, I mean, the eyewitness identification of the two individuals, the two men, the two DPW workers, that was not a very, one of them, of course, could not identify your client at all. And the other one misidentified your client, so to speak. And wasn't the point made by defense counsel that my client may have been there, but all he did was take a swing? Somebody else, or someone that no one saw or identified, was the one who was actually, I'll use the word pummeling the victim with his hands. So why is that so unreasonable?
Well, first of all, I would say that it is true that these witnesses who were across the street could not pick out his photo from a photo array. However, the description that they gave completely matched the defendant in every way, and they were able to spot him 2 hours later in a different part of town and called the police and said, that's the guy. And it was Mr. Benjamin, and he was picked up and he subsequently admitted to it. So I think the identification evidence, despite the photo array, was very, very strong. With respect to your second part of your question as to, didn't the defense attorney try to make the point that someone else was involved? Mm-hmm. I would say no, for a bunch of reasons. First of all, his closing argument, I agree, he's trying to sort of hint at that. He does a terrible, terrible job of hinting at it. But more importantly, he doesn't bring up any evidence during the trial on cross-examination that he could have used to show that there were other people there. Both of the eyewitnesses testified that nobody else was around the victim and the defendant when this happened. Mm-hmm. However, there was a police report where the police had interviewed one of the eyewitnesses right after the fight, and he had said, this is Mr. Foodie, I believe, he had said there were 4 other people 2 feet away when the fight happened. For some reason, the defense attorney doesn't ask him about this at all. So I think if he's trying to make the point that someone else did it, I don't understand why he wouldn't use that evidence that was available to him. And that is in my record appendix, that police report. Mm-hmm. I think what the Commonwealth points to in trying to sort of make the point that you were just making is that Shin and WARE testified that there were other people around, but Shannon WARE was a completely discredited witness. She basically admitted on the stand that she didn't remember anything because she was too intoxicated, and she had just read a police report that the prosecutor gave her prior to her testimony, and that's what she was testifying based on. So, so there's really, I mean, there's not really anything else that the defense can point to, I mean, that the Commonwealth can point to show that the defense or anybody tried to bring up that there were other people around. Although he should have, of course. I mean, if that's the point that the defense attorney was trying to make, of course, he should have. In addition, you know, when I argue this in my brief, it wouldn't have been that difficult to try to establish that there was a period of time after the fight happened when Mr. Foodie and Mr. Luma, the two eyewitnesses, weren't paying attention to what was going on. That this was really, really important because, you know, like I said, when you look at the evidence from the eyewitnesses, it's very compelling. I mean, they're right across the street, and they testify that they see the whole thing from start to finish. There's nobody else around. It's just the guy who matches my client's description and the victim. But if you read through the transcript, you can see that there were opportunities for the defense to poke holes in this, and he just completely doesn't do it. One of them is in reference to the 911 call, which if you look at the trial testimony from Mr. Foodie, he makes it sound like he called 911 after he went up to the victim to see if he was okay. But in one of the police reports, it's pretty clear that he made the 911 call earlier while he was still in his truck. And then you had the test, so that there's a possibility that his attention was drawn away from the scene. And then with respect to his co-worker, Mr. Luma, there's a very brief sort of offhand remark during direct testimony where he says, oh, well, I looked around the truck for some rubber gloves. Now, you know, I know what you're thinking, like, oh, well, so the jury heard that. But my point is the defense attorney, with no other defense, because, you know, my client has admitted to being involved, had to take advantage of some of these pieces of evidence that were right there.
His closing argument really did make some inroads, if you will, as to how valuable those two eyewitnesses were. I mean, I think he made the point that they weren't even on the same page and they were sitting in the same truck. So there was some marshaling of evidence in the defendant's favor.
I agree that, you know, but that's kind of part of the problem is that, you know, his closing argument was so confusing and really incomprehensible.
Well, let me ask you this.
Yeah.
It's easy to poke hole. I mean, and hindsight, you know, is what they say is 20/20. But in your case, not only do you have to show, as you know, that that the defense attorney did not, you know, his behavior, his conduct rather, fell below what we would expect from an average attorney, but also that it deprived your client of another substantial defense. And that's where I can tell you right now that I have some trouble with your argument. So you want to address that aspect of it?
Yeah, I completely understand. I mean, it's a two-part test. You know, it's not enough for Mr. Benjamin to show that his attorney did a bad job. He has to show that it may have made a difference. Now, I will say that he doesn't have to show that the evidence or the defense that I'm going to suggest would have led to a not guilty. It just has to have been something that would have been considered important by the jury. So my contention with respect to that is there was an opportunity to raise this causation defense. Based in part on that time gap I was just talking about. You had to show that there was a time between the end of Mr. Benjamin's striking the victim and, you know, when the witnesses went up to the victim, that there was a time gap. So
that's evident in the evidence, right?
Not really, because the witnesses didn't testify that. The witnesses said as soon as he was down, the victim was down. They waited 10 seconds and then they went up to the victim. But there were these other, like I was just saying about, like, you know, the thing about the gloves and about the 911 call, there were opportunities to kind of like create this doubt about whether those witnesses saw what really happened right after.
So your point is creating doubt would have been the substantial available defense that was not pursued?
Well, that's part of it.
On the aggravation.
Yes, this only goes to the serious bodily injury causation.
Right.
It has nothing to do. Mr. Benjamin completely admits that he committed assault and battery. He's been saying that since day one.
Right.
In fact, he was going to the police station, he says, to go confess to it. But he was adamant that he did hit him, but he did not, there's no way that what he hit him caused this. And there were other people around. So I want to be able to get to your question about what is the defense that was deprived. It's this ability to raise reasonable doubt about whether or not what Mr. Benjamin did caused these injuries, or if one of the other people who was standing 2 feet away, and these were two groups in the park that fought all the time. It was kind of like a turf, I don't know, like a turf thing. So there were other people with Mr. Benjamin when they confronted the victim. So, and then you have this, the medical evidence where, there's tons of notes in the medical evidence about the victim had this large golf ball sized lump on his forehead, which is where the hematoma was. Okay. The Commonwealth's theory of the case is that my client strikes him while he's sitting down, the victim, and the victim falls backwards onto the grass. So, the question becomes, okay, well, how does he get this golf ball sized lump on his forehead? Now, I don't know, but if I was the defense attorney, I would sure try to raise a reasonable doubt about whether, punching somebody and then falling backwards into the grass could have caused this.
But he said he punched him repeatedly, that it was like I don't know what those initials stood for, but some
UFC.
fight thing. Thank you.
Yeah.
Justice Vuono. But,
Yeah.
right, so if those witnesses were believed, the series of punches, one of those produced the hematoma.
I guess Your Honor, I guess it's possible. I just know as a lay juror and as a defense attorney with lay jurors, you need to, work that reasonable doubt in if you can. Now, I'm not saying it would necessarily have been successful, but based on the evidence, there was no way that misidentification was going to be successful. There was no way self-defense was going to be successful. This was the only opportunity, and the evidence was there. I mean, there were thousands of pages. I could show it to you. The medical records, were like feet high, and it was pretty unrealistic for the defense attorney to think that the jury was going to go through this, and find all of these notes in there.
Why do you say there's no way those defenses would have been successful? I mean, the jury actually did ask about self-defense.
Yeah.
Given his statement, it seemed like self-defense was a reasonable ground to explore. Given the eyewitnesses' inability to pick him out of a photo array, it seems like misidentification was at least a reasonable ground to explore. And, I read the closing to be arguing that the guy that these witnesses saw punch him and causing these injuries was not, in fact, the defendant. And while there might have been an altercation at some other point, that his defense to that was self-defense. Why is that manifestly unreasonable, especially given the hand that he was dealt? I mean, it seems like he was arguing what you're saying he should have argued, that somebody else caused the injuries, just in a different way than what.
Well, I first would say that misidentification made no sense because the defendant placed himself there. He gave a full confession to the police.
Right, but not necessarily at that time. That's what I gather to be the gist of the closing, that there was some other assailant who the two witnesses sitting in the truck saw who caused these injuries, and there was an altercation at some other time between the defendant and the victim.
Oh, I don't think so, Your Honor. I mean, this all happened within a few hours' time, and the victim was, seriously injured during this altercation, and there was no other altercation. I mean, there's just the one assault.
Well, no, the argument I understood it to be is that the description of your client was so ambiguous. Somebody with dark clothing or not dark clothing, whatever, that it easily could have been somebody else that had intervened, and that so that you could believe your client that he had only taken a swing and that was it, and somebody else could have caused the injury. I don't mean to interrupt Justice Shin's train of thought there, but was my understanding.
I mean, I understand what you're saying. And I think, like I said earlier, I think he was trying to sort of hint at that towards the end of his argument. But number one, he doesn't bring up any of this evidence about other people being around. the eyewitnesses said nobody was around. The police report says there were other people around, but the defense attorney didn't use it. So if that's what he's trying to argue, I don't understand. And, the other thing I would bring up is that, the prosecutor in her, or I think it was a female, in her closing responds to his closing as if he's arguing misidentification. So this whole other person, it's really just more about, he talks about the eyewitnesses being liars or being stupid. It's very hard. It really is actually very hard to comprehend. But I think with the defendant's admission that he was involved without the defense bringing in any other evidence that anyone else was around, it just makes misidentification kind of a ridiculous argument in the closing. And then with respect to the self-defense, I would just say that, the jury did ask about this, which I don't blame them. I mean, the defendant's version of events is basically like a mutual fight sort of a situation. But I mean, everyone knew in the court, the judge and the attorneys knew, I'm sure, that as soon as the jury was instructed on self-defense, they weren't going to come back with self-defense because there was no legal basis or factual basis for self-defense at all. So I think the fact that they asked the question, I mean, they're lay jurors. They don't know what the legal definition of self-defense is, but of course, as soon as they heard it, they rejected it. So if there are no other questions, I'll rest on my brief for the remainder.
Okay, let me just check with the panel, see if there's any follow-up questions for you. I see none from Mrs. Hanlon or Mrs. Shin. Thank you very much.
Thank you.
We'll turn now to Attorney Elliott and hear the Commonwealth's point of view.
Thank you, Your Honor. May it please the court, Krista Elliott for Middlesex on behalf of the Commonwealth. I would first I'll start in the same spot that my sister left off at in regards to the ineffective assistance of counsel claim. Here, the motion judge, who was also the trial judge in this case, correctly rejected the ineffective assistance of counsel claim. This is a case in which trial counsel was actually quite effective. The Commonwealth's case was very strong. There were 2 percipient witnesses to the attack on the victim. And not only that, but as has been discussed, the defendant, in fact, admitted to his involvement in the attack on the victim. However, despite this hand that trial counsel was dealt, trial counsel was able to marshal 4 separate lines of defense. First, he undercut the credibility of the Commonwealth's witnesses repeatedly by marshaling all sorts of inconsistencies in their testimony. He was able to allege that there was an unidentified third party that contributed to the victim's injuries. He was able to put forth a subsequent fall theory. And he was also able to essentially put forth a self-defense theory that, as Your Honors have pointed out, garnered enough attention that ultimately the jury returned a question on it. These were defenses that were woven throughout trial, and certainly this is not a case in which there were 2 inconsistent defenses that were argued. Further, the defendant's claim that he was deprived of a substantial ground of defense is simply meritless. Here, the trial counsel adequately argued that both the subsequent fall theory and hinted at a third-party culprit theory, which is essentially what my sister would now assert was not argued at trial. And I would like to just address this evidence a little bit at this point, because when looking at the medical records in this case, the subsequent fall theory and the third-party culprit theory essentially hinge on notations that the defendant or that the victim was hit with a beer bottle. Now, we know there was a beer bottle on the scene because the victim was in fact drinking a Corona, but there is no indication as to how any of the information about the mechanism of injury would have been transmitted to the hospital where those notations were made. The victim was unconscious and in a coma by the time he arrived at the hospital. None of the percipient witnesses arrived at the hospital, and therefore the only way that any of this information about a beer bottle could have arrived at the hospital was via information from the first responders who did not see the attack. As such, this information was hearsay, it was not diagnostically relevant, and certainly would not have arisen to the level that would be required for a third-party culprit defense. And as such, even if there were a new trial in this case, all of this information about a beer bottle would be redacted at a second trial. This information was not properly before the court at the first trial, and as a result, trial counsel was able to leverage it, which is not something that would happen on a retrial. As to the,
excuse me, I'm sorry, but why is it not diagnostically relevant? Like how, I mean, you frequently see how the injuries were acquired in medical records.
Certainly, but this is not information. This is all supposition, essentially. There is no percipient witness would have been able to say how this injury had happened. The victim, even at the time of trial, had no memory of the event. And so there is no person who would have either witnessed the event, and there's no report from the victim as to how he received those injuries. And so it is all purely speculation in this case.
So
Turning
you said earlier, and you say in your brief, that the purpose of the closing was to undermine the credibility of the eyewitnesses. But
yes, Your Honor.
To what end? I mean, what's the purpose of undermining their credibility unless he was arguing that the identification was wrong? And you say it's not misidentified, but I don't understand then why you would undermine their credibility, what the purpose is.
So I think that it's a little bit confusing, because really the undermining of the credibility does relate to misidentification, but only insofar as it relates to this third-party culprit defense or a subsequent fall theory. And so really it's the question is whether or not the percipient witnesses were appropriately observing everything that happened. And I think it goes toward that. And as Your Honors have pointed out, it would have been very strange for trial counsel to have ignored the issues in relation to identification entirely in this case. But regardless of the amount of evidence related to, or the argument related to misidentification, that was not the primary purpose of the closing argument. The primary purpose of trial counsel's closing argument was to raise a doubt in relation to the credibility of the witnesses, and also in relation to who had been the final person who essentially put the nail in the coffin.
To what end? And so, okay, so he attacks their credibility, but so what? Unless he's arguing that they misidentified the defendant as the assailant. Do you understand my question? I mean,
I do.
I'm reading the closing and I'm trying to kind of glean what the theme is, and it seems to me he was arguing misidentification, but you say he was not. So I'm not understanding what you're saying the purpose of the closing was.
Well, Your Honor, I believe that I do certainly see your point in the context of the closing. There was a lot of argument in relation to misidentification, but specifically, the closing to me reads more as a marshaling of every potential defense that could have been raised at that point. He certainly is raising the bland identification and that he claims that these two witnesses made, highlighting the fact that they were unable to actually identify the victim, and highlighting their inconsistency, or excuse me, identify the defendant, and highlighting their inconsistencies also went toward questioning what they actually saw. He highlights the fact that these were two men who were sitting in a truck together, and yet their stories differed slightly. And so highlighting those inconsistencies goes toward just raising that reasonable doubt that my sister has been speaking about throughout this argument. And without highlighting those inconsistencies, the trial counsel would not have been able to attempt to leverage a reasonable doubt in the way that potentially the evidence could have allowed him, and did in a way allow him to.
So in other words, nobody has a reliable account of what happened on that day. That was the theme of the argument.
Exactly, Your Honor. In addition to, kind of the other theme was no one has a reliable account on that day, with the exception of the defendant, who has produced this single account of what happened that he repeatedly stated. And I think that was really the ultimate theme. Moving on to the causation argument here. The causal connection between the defendant's assault and the victim's injuries was readily apparent to the jurors. There was no merit to there being any reason to need an expert in order to assess this causation here. I would point Your Honors to Commonwealth v. Beal, that's at 474 Mass 346. That's a case in which there was a gunshot wound that essentially rendered a victim unable to walk appropriately. And the court found in that case that it didn't matter that the jurors may not understand the exact biological mechanisms of the injury, but it would certainly be within the ken of a lay juror to understand that a gunshot would in fact impact somebody's ability to walk. Further, there was no error in the omission of the portion of the causation instruction when it was done at the defendant's request and for the defendant's benefit. And finally, the Commonwealth did not withhold any grand jury evidence and did not mislead the grand jury in this case because there simply was no witness that would have testified as the defendant would like this court to believe. And if there are no further questions, I would rest on my brief.
All right, well, thank you very much. I'm going to check with my panel members here, and I see no further questions, no more follow-ups. I want to thank you both very much. The briefs are very clear. Your arguments are very helpful. We'll take the case under advisement, and we will get an answer back to you.
We are live.
Okay, thank you very much. That 20 seconds always seems rather long, doesn't it? Good morning and welcome to today's remote sitting of the Appeals Court. My name is Ariane Vuono. I'm joined today by Justice Sidney Hanlon and Justice Sukyoung Shin. Before we begin, before I officially call your case, that is, I would like to give you two quick reminders. The rules of appellate procedure that pertain to oral argument in a courtroom apply to argument on the remote platform as well. So you each have 15 minutes to make your argument and there is no rebuttal. And second, as our clerk already explained, upon occasion we have some technical difficulties. If that happens, just be patient. We can usually resolve them quickly. And I want to assure you that no one will lose any of their argument time if anything like that happens. So I'm going to call the case, Commonwealth versus GARNELL GONSALVES, 2019-1167, and ask Attorney Methe to begin your argument now.
Thank you, Your Honor. May it please the court, my name is Attorney James Methe. I represent GARNELL GONSALVES in this appeal. I'm going to start out arguing the first issue in my brief, which is the judge abused his discretion when he denied trial counsel's motion to exclude the text messages from evidence. I'm planning on spending most of my time this morning on this issue because the text messages were basically the entire case against my client with the crimes he was convicted of. The judge's decision in this case was wrong. He said he was concerned about the deletion of the text, but he decided to admit the text anyway into evidence. First of all, he said he was denying it because there was no state action, which is incorrect because Officer Tremblay told Ms. Dixon to delete all the non-threatening text. So he told her what to do.
That's disputed though, right? Didn't the officer testify that he didn't tell her to deliver anything, or do I have that wrong?
That you may be correct on that, but Ms. Dixon testified both on the voir dire and during the trial that Officer Tremblay told her to delete the non-threatening text, and that she deleted 50% of the text. And in addition to that, when she went to see Sergeant Mello at the police station, Sergeant Mello told her, just take a screenshot of this one and that one and forget the rest.
What's improper about that?
Pardon me?
What's improper about that? I mean, is it Mello? She didn't tell her to delete anything. She just said, I want screenshots of certain text messages. That seems entirely proper to me.
Well, when you tell somebody you want screenshots of this one and that one, I think the assumption would be they're going to get rid of the rest. And that's the whole point here is we don't have these deleted texts. The loss of destroyed evidence.
The only way you could prosecute this guy is to take the woman's phone away from her and for several weeks and send it, as I understand it, to the state police. And
right, that's what they should have done. They should have taken her phone as evidence, which they do all the time, and they should have had it dumped. They shouldn't have asked her for a consent to take the phone, because if they had taken the phone and hadn't it dumped, then we'd have the phone records and there'd be no question about authentication or what the deleted texts were.
well, there's not really a question about authentication, right?
Well, I wasn't going to argue authentication this morning because I thought
fair enough.
that was probably not the weaker argument of the two. But
Fair enough.
When you refer to this lost evidence, so to speak, or deleted, the deleted text, etc., but wouldn't it be important to have some sort of understanding whether or not any of those texts were exculpatory in some fashion before we can even evaluate whether or not there was any prejudice to the deletion of the text?
Well, we can't, I can't show whether they were exculpatory because I don't know what they are. So,
Well, your client's the one who sent them.
right, but we don't know.
He has some sense that, first place, they started out on his phone, right?
That's correct.
And
But we
then,
don't have, oh, go ahead, Your Honor.
and then, yeah, and then he knows what he sent
Right,
and what he
but
got back. Sorry, now I'll let you talk.
But the problem is there's no evidence of what kind of phone he had. I mean, there's certain kinds of phones, I believe you're not going to be able to get these text messages that he sent. So there's no evidence of what type of phone he had that he was able to retrieve these text messages. So going back to the judge's ruling, he never really reaches, he says there's no state action, so he never reaches the issue of whether my client met the initial burden to show that the deleted text would have been favorable to him. And then the last part of his decision is sort of odd too, where he says the jury can determine whether the deletions have probative value. That doesn't even really make any sense to me, because how can the jury determine whether it's something they don't see has any probative value in the case?
Well, it's the missing witness argument, right? You argue that she selectively deleted, them, and that she took out all the stuff that would have helped your client. Can argue that to the jury, right?
He did argue that to the jury,
Mm-hmm.
that there were missing texts and we don't know what they were. And
That's what the judge meant when he said, right, the jury can decide, right?
pardon me, Your Honor?
Arguably, that's what the judge meant when he said the jury can decide, right?
I don't really know what he meant by that, because I don't know how a jury can decide on deletions when they don't know what they are. So going back to your question before, the police should have gotten the phone. They made two mistakes. They should have gotten the phone. They should have dumped it. It's very common to get phone records today. And they shouldn't have told her to delete the text. That was reckless conduct on their part and in bad faith. And even if their conduct doesn't reach that level and is negligent, I think my client's still entitled to relief because she deleted the non-threatening text as Officer Tremblay told her to do. Deleted texts are important in this case because the Commonwealth has to prove some things, the elements of these two crimes, the stalking and the intimidation of a witness. They have to show that she was seriously alarmed or annoyed. And they also have to show, under the harassment definition of intimidation of a witness, that she was a reasonable person would suffer substantial emotional distress. So without those deleted texts, we don't really know whether those elements were actually met. And I gave an analogy in my brief to a situation where the police go to a crime scene and there's a civilian there who say found some evidence, whether it's a weapon or clothing or whatever it is, and they say to the police, well, here's some evidence, I think this might be important, do you want this evidence? And the police say, well, we'll take this and we'll take that, but you can throw the rest out. So certainly that would not be condoned in a criminal prosecution. It would be improper and would entitle my client to relief. The deletion of the text was obstruction of justice. It was reckless and in bad faith, and it was a violation of my client's due process rights. I want to just tie in briefly my argument on issue 4A of my brief concerning it was ineffective assistance for trial counsel not to file a motion to dismiss the indictments for this very reason. Ms. Dixon testified to the grand jury that she had deleted the text, but didn't say that police told her to delete the text. And again, the deleted texts were important enough for a probable cause on the two crimes he was convicted of.
But if she told the grand jury, that she deleted some, why would it matter if whether she told the jury that it was Officer Tremblay who instructed her to do so? I don't see why that would have changed the outcome.
Well, I would argue that it's deceptive and misleading evidence because we don't have presented to the grand jury because we don't have the missing text.
But she told them that, right? She told them that she
She
deleted.
told them she deleted the text, right? She didn't tell them that police told her to delete the text.
Are you saying that the fact that the police instructed her to do that is so egregious that it should warrant dismissal of the indictment on that basis, that the Commonwealth's conduct was egregious? Is that your point?
Well, there's that point, and again, the fact that we don't have the deleted text can't be presented to the grand jury is deceptive and misleading evidence. So 2 grounds.
And if that had been the case, wouldn't the Commonwealth be able to re-indict the case?
I suppose they could try to re-indict the case. That's true. I'll move on now to the second issue in my brief, which was that the omission of the definition of moral certainty from the judge's instruction on reasonable doubt was substantial risk of a miscarriage of justice. The judge did not give the definition of moral certainty from Russell, which was decided 2 years before this case. And the Russell case does say, quote, judges are to instruct the jury as follows, end quote. Now, I know the assistant DA in the appeal brought up Commonwealth versus Whitson case, which was decided last year, which was the case where I argued on appeal. It was the same judge and the same trial in the same month, but I filed my brief prior to the Whitson decision coming out. But in Whitson, the court did say that it was error for the judge not to use that language from the Russell case. It just said it wasn't a substantial risk of a miscarriage of justice. So I would argue that the definition of moral certainty that was left out, which is, quote, the highest degree of certainty possible, end quote, is a higher standard than the inviting conviction to a moral certainty. And then my client didn't receive that higher standard. And I asked this court to reevaluate or find it in this case, a substantial risk of a miscarriage of justice occurred, even though they didn't find that in Commonwealth versus Whitson.
But is there any material difference between the 2 instructions, the one that was given here and the one that was given in Whitson?
No, they're exactly the same.
Oh, okay. So you're asking us to reconsider Whitson?
Yes.
Okay.
I'm going to move on to issue 4B in my brief, which is that counsel was ineffective for not requesting certain jury instructions. Counsel did not ask for about an instruction, which is odd because the thrust of his closing was what the police didn't do, that they didn't get her phone, they didn't get the phone records, et cetera, et cetera. So it seemed
Any
natural.
case, I'm sorry, because the interrupting is awkward in this, I apologize. Is any case ever been reversed for failure to give a Bowden instruction?
I'm not sure on that. It's possible that they haven't been. And I understand the counsel was allowed to argue in his closing that the police should have done certain things.
Okay.
He also did not ask for an instruction on loss of destroyed evidence, which again would have been, it seemed like the natural thing to do because he argued throughout the trial that there was this loss of destroyed evidence. And if the judge had granted that request, the jury would have been told that they may draw an adverse inference against the Commonwealth because of these deleted texts. I'll briefly talk about issue 3 in my brief, which is the denial of required finding of not guilty on the charge of stalking in violation of restraining order. My argument was that the element of knowledge of the order was not met. There was no evidence that the trial and my client were served with the restraining order. I understand that there was certain text that he sent that would indicated that he knew that there was an order. He said, why did you put papers out on me, and what makes you think any piece of paper is going to stop you from getting blankety blank? So I understand there was knowledge he had knowledge there was an order. The question is, did he know the terms of the order? And Commonwealth versus White that I cited in my brief, which is directly on point. I didn't realize it's an unpublished case from this court. But in that case, they found no probable cause for a complaint where it appeared that the defendant knew about the order. He said, quote, what is this court blank? So it was clear that he knew that there was an order, but the court found there's no evidence he knew the terms of the order.
Right, but the difference here is that, so he sends a text at 5:06 indicating that he knew that she had gotten an order and they're trying to serve him with the order. Then he proceeds to send texts throughout that evening, some of which were threatening. And he continues to text through January 10th. And the first text, I believe, was sent on January 5th. So 5 days later, he's still sending her texts. So at some point in those 5 days, isn't he on duty of reasonable inquiry once he knows that there's an order that's been issued?
Well, I would argue he didn't have a duty to inquire. I mean, the White case doesn't say anything about that defendant's duty to inquire. They found that just the fact he knew about the order was not enough.
So somebody could willfully avoid being served for weeks and then assert lack of knowledge of the terms of the order as a defense? And could he have gone to her home, showed up at her home?
I'm not.
So
Okay,
he's sending texts indicating that he knows they're trying to serve him, but you know, he kind of taunts her and says they're looking for a ghost because I'm not here. I'm in Boston. I'm in LA.
Yes.
So somebody could just avoid being served. See, that it seems to me your argument is someone could just avoid being served and blind themselves to the terms of an order that they know is out there forever, and then assert lack of knowledge of the terms of the order as a defense. Right? I mean, is there any limitation to what you're arguing?
Well, it doesn't seem they made much of an effort to serve him with the order. It appeared that they went one time to his house or where they thought he lived and weren't able to serve him then, and that was the only evidence that they even attempted to serve.
Okay, but there's no duty of reasonable inquiry. So say that he sends the text, he knows they're trying to serve him, she has an order, and then a week later he shows up at her front door. That would be okay?
Well, if he doesn't know the terms of the order, then I think he can. Anyway, that's my argument.
All right, I understand.
If there's no further questions, I'd ask this court to reverse the judgment. Thank you.
Okay, I see no further questions. Thank you very much for your argument. We'll turn now to the Commonwealth and hear from Attorney Gauthier.
Thank you, Your Honor. Good morning. Stacey Gauthier on behalf of the Commonwealth. The defendant has raised 4 issues here. However, it's the Commonwealth's position that his conviction should be affirmed. I'll start with issue number 1. The judge did not abuse his discretion in denying the defendant's motion in limine to exclude screenshots of the text messages. Here, the defendant is first claiming now that they were lost or destroyed. It's the defendant's initial burden to establish a reasonable possibility based on concrete evidence that access to the lost or destroyed evidence would have produced something favorable to his case. And here, the judge didn't think it was state action or deliberate action by the police to preclude the defendant from having exculpatory evidence. He thought it was an issue for the jury. That was the judge's discretion in issues of lost or destroyed evidence. It's the judge's discretion what the remedy will be. And here, he thought the remedy was to send it to the jury and let the jury decide. In addition, the defendant has failed to even prove that he didn't have access or that the evidence was actually lost or destroyed. A text exchange is preserved on both phones. So the victim's deletions on her phone would not delete them from the defendant's phone, nor would they delete them from the phone records in the possession of the service provider. There was nothing stopping the defendant from screenshotting anything that he found was or thought that was exculpatory on his own phone and presenting them at trial. In addition, he could have also got his own phone records from the service provider and used those at trial. He could have also attempted to get a court order to get the records from the victim's phone as well. He would have had her her phone number and her information from when they were texting during their relationship. However, even if the texts were not actually available to the defendant, he still failed to meet his burden to show that they were potentially exculpatory. To meet this burden, he would have to articulate what exculpatory information that he believed the evidence would have. Here, he claims only that the texts, quote, may have been statements that he didn't really mean what he said. or that she could have stated that she wasn't really afraid of him. However, this is purely speculation. In the tenor of the numerous threatening text messages that the defendant sent to the victim over a matter of weeks certainly makes that possible. That makes that exceedingly remote, that possibility. Further, if the defendant was, he was involved in these conversations, he should have been able to at least point to one concrete, incident where he said something, where he told the victim that he didn't mean what he said, or where she had specifically said that she wasn't afraid of him, and he didn't do that either. So I would suggest that for those reasons, the judge did not abuse his discretion in denying the motion in limine to exclude screenshots of the texts. With regard to issue number 2, the jury instruction on reasonable doubt, I would just ask, the Whitson case is a relatively new case, and I'd ask just that this court not reconsider it at this time. It was the same judge with essentially the same jury instruction as was affirmed in Whitson. And then with regard to issue number 3, there was no error in the denial of the defendant's motion for a directed verdict on the charge of stalking in violation of a 209A order. The defendant, again, only challenges the notice element. And we know that personal service of a restraining order is not required if the Commonwealth can show that the defendant had constructive or actual knowledge of the existence and the terms of the order.
What's your strongest case for the principle that constructive knowledge will do?
I would think that would also be in Commonwealth versus Welch, which I know at the end wasn't good for us. However, that's the case that says that knowledge may be shown by presenting evidence sufficient to prove that the defendant had actual knowledge of the terms of the order or was put on sufficient notice to make reasonable inquiry concerning the issuance and the terms of the order.
But it doesn't explain what that means. It doesn't explain what reasonable inquiry means. So is your argument that knowledge of issuance of an order ipso facto means that the defendant has constructive knowledge of the terms of the order?
No, I think it's different. I think knowing about the order and the terms of the order are different things. And I would suggest in this case, I think it was clear from his text messages that he knew that there was an order in place. And based on the text messages that he sent, which indicated that he knew that the order was in a place, at that point, it would be his responsibility then to, go to the court or call the court and find out what the term, or go to the police station and find out what the terms.
It does sound like you're arguing that once a defendant has knowledge that there's an order in place, that they have a duty of reasonable inquiry to go get the order and find out its terms. Is that what you're arguing? Is there any limitation to what you're arguing? So let me give you a hypothetical. Let's say he sends the text message at 5:06 p.m. indicating he knows that she's gotten an order. A few minutes after that, he texts, let's say, her mother and says, please tell her not to do this. And now that's a violation of the terms of the order, let's say, because it prohibits contact through a third party. Is he deemed to have constructive knowledge of that term?
I'm sorry, it was like 3 minutes later that he texted?
Yeah, let's just say a short time later, he knows there's an order. A short time later, he contacts a third party and says, please tell her not to do this. And that is technically a violation of the order because it prohibits contact through a third party. Is he deemed to have constructive knowledge of that term of the order?
I mean, that's a little soon. In this case, we have the defendant sending text messages saying, I'm not new to this, right? So we know that this defendant, he's aware of whatever. I think the jury could have inferred that this isn't the first time he'd been served with a restraining order. So this defendant in particular has knowledge of what a restraining order is and that there's terms and conditions of it.
But it's not just that it's soon. It's also that in Judge Shin's hypothetical, it's an order that you wouldn't normally anticipate, right? That is, right? It's third party contact. I mean, you couldn't if there was an order to surrender the keys, or if there was an order to stay away from her workplace.
Yes,
He
but
can't be,
certainly to continue calling the victim or the person who got the restraining order, and to make, threats like, this piece of paper doesn't mean, anything, and it's not going to keep you from getting your ass kicked. I mean, that is certainly, I think, something that a reasonable person would anticipate would be in a part of a restraining order, is not to threaten the person.
So
But
are you saying that
someone,
the duty of reasonable inquiry is triggered by whether the term would be, I'll just say, obvious to a reasonable, that there would be such a term in the order, or is it triggered by the amount of time that passes? I'm just trying to understand what the limitations are on this principle, because Welsh doesn't explain what they are.
right? And I think it's got to be a factual question. I think it's gonna be different depending on, different cases, what the violation is, if there's any evidence that the defendant has had prior restraining orders before, so maybe he's a little more knowledgeable than just Joe Schmo. This guy, he was taunting her, as Justice Hanlon pointed out, by texting her saying, "Oh, they don't mean shit until I'm served, and I'm in Boston. Tell the police to stop looking for me. I'm in LA." That's, in a case like this, this defendant certainly would have been on notice to make a reasonable inquiry as to the terms of the restraining order.
Okay.
did any of this get explained to the jury?
Well, the judge instructed the jury the judge explained to the jury that sufficient notice to make reasonable inquiry means, in this context, that the amount of information which would cause a reasonably prudent person to make an effort reasonably intended to learn of how the terms of the order would affect his or her further conduct. So he did give the jury instructions on that.
So in the 128 cited by the defendant, White, if I'm recalling the facts of that case correctly, the defendant knows that there is an order in place, and then he calls her, right?
That's correct.
And we concluded that there wasn't probable cause to issue the complaint because there wasn't enough evidence that he knew that he was prohibited from calling her. Is that the right result in your view?
No. That case, first, I point out that's a 128. And this court
I understand.
certainly isn't bound by it. That case doesn't talk about the reasonable
Inquiry.
Thank you. I'm sorry. That doesn't talk about the reasonable inquiry. So I don't think it's the right result. However, what I would say is, in that case, the defendant only says something like, "Oh, what is this court's business?" In this case, the defendant's talking about, a piece of paper, it doesn't mean anything until it's served. Like, the defendant's text messages in this case were much more specific and directed specifically to a restraining order in this case.
Well, I have the case up here. It says, what is this court SHIT? And then it says, "You're ruining my life more than you already have." So that could be interpreted as a threat. No.
Yeah, it's not like, a piece of paper isn't gonna keep you from getting your ass kicked like the threat was in this case. I just think this case is more specific to the restraining order, and definitely more of a threat.
So on the facts of White, once the defendant knew that she had gotten a restraining order, he has constructive knowledge that he's not allowed to call her. That would be your position?
Yes, although I think.
And why? I mean, I'm just, it's really difficult to kind of define what the parameters of this duty of reasonable inquiry is.
Well, certainly, I think it would be you would be on notice that you would not be able to keep, a restraining order is, I think, in common knowledge, a restraining order is so that you stop harassing somebody. And so I certainly think that you know,
Or so that you stay,
contact.
or that you stay away from somebody.
Yes, and I would suggest that, you know, contacting them is not staying away. You know, it's continuing to harass them.
But
would be-
contact through a third party
That's,
would be,
I mean, that might be a little, I mean, it might be a little different, although, I mean, certainly, again, it's contact and it's not, I mean, I guess someone could think that that was staying away from
But
somebody, but certainly,
In Melton, the court made it clear that it was the fact that the plaintiff in the restraining order, the victim in the case said, you can't call me at something like,
Yes,
you can't
yeah.
call me, I've
He
got a
specifically
restraining
told
order.
them, yes.
It was explicitly that knowledge, and so, right,
Yes, yep.
that term that he had notice of.
Well, would you say, Counselor, that reading through the text messages that were introduced to the jury, would you say that you could infer from them that this defendant knew something along those lines? At least I know I'm not supposed to call her. Or are they really just, you know, taunting and threatening and things like that? Or how would you view that? In other words, is there anything you can put your finger on that says this shows he knows he's not supposed to do this?
I would suggest that by him saying that, you know, they don't mean shit until I'm served on them, shows that, you know, he knows that he's not supposed to be contacting her, and he's going to continue to contact her until he gets served. So I would suggest that that's the text that came in that shows that he has knowledge. Plus, and then he's texting her, you know, seemingly, you know, purposefully avoiding being served. He's like, oh, tell the police they're looking for a ghost. I'm in Boston, and, you know, now I'm in LA. I think that shows that he knows that he's not supposed to be contacting her, but he also is aware of the service requirement. I don't think that he can use his knowledge of restraining orders to avoid service so that he can keep, you know.
right, I mean, I think they certainly show that he's trying to avoid service, but it seems like he's saying until they serve me, there's no order that's effective. And
I can keep calling you and harassing you.
Right, right.
Well, no one tried to answer him, neither the victim in this case, or nor did the police text and say, you know, there is a restraining order and stop contacting this person, and where are you? I'm going to serve you. Nothing like that happened either in this case.
No.
Yeah. Okay. Well, I see your time is up. I'm going to check with the panel to see if anyone has any further follow-up questions, and I see they do not. I want to thank you both very much. The briefs were helpful. The argument today was very helpful. We appreciate your coming and participating in this forum, because it helps us move our cases along. We'll take this case under advisement, and we'll get an answer back to you as soon as possible. Okay, thank you.
Thank you.
The oral argument, as if we were in the courtroom, apply in this remote sitting as well. That means you each have 15 minutes to make your argument, and there is no rebuttal. And second, upon occasion, we do experience some technical difficulties, or let's just say there's the possibility of experiencing some technical difficulties. If that is the case, please be patient. Usually they're resolved quite quickly. And I can assure you that neither one of you will lose any of your allotted time should something happen during the course of your argument. Okay, so with that said, I'm going to call the next case, 2020-0159, Justin Nielas versus Molecular Health, Inc., and ask Attorney Ackerstein to begin your argument.
May it please the court, Michael Ackerstein, counsel for plaintiff appellant Justin Nielas. Before this court is Mr. Nielas's appeal of the Superior Court's award of summary judgment as to his claims of discrimination and retaliation against his former employer, Molecular Health, based on his termination in February 2018, shortly after he complained about discrimination.
And can I just interrupt to say, what's the best evidence in the record that leads you to the conclusion that there was a basis for that complaint, right? That is that he was being discriminated against because he was gay. What in the work environment, and also if you could factor in the fact that they seem to have kept 2 gay men out of 4 after laying off about 100+ people.
Certainly, Your Honor. The best evidence in the record that Mr. Nielas's underlying complaint of discrimination was motivated by good faith is that he had had a pattern of hostile treatment from Mr. Saliani over a course of months.
And how do you distinguish that from just the two just didn't get along and didn't like each other? I mean, was there ever, I couldn't find anything in the record about anything homophobic or discriminatory from Mr. Saliani or anybody?
Certainly, Your Honor. If you're looking in the record for evidence of a homophobic comment, you're right, you're not going to find it. What's contained within the record is Mr. Nielas's perception that he was subject to a campaign of embarrassment and humiliation based on his sexual orientation. I recognize, to your point, Your Honor, that might not be a convincing or winning claim of discrimination as to the conduct up to January 25th, 2018. But Your Honor, I'm not sure that issue is before the court. Right? What's at issue is whether or not Mr. Nielas was subject to discrimination when he was terminated in February 2018, and whether
because I understand the retaliation claim is separate.
Sure.
But that he was terminated because he was gay.
Well, yes, Your Honor. So I think, Your Honor, you're asking me to answer two different questions. One is, what evidence of discrimination is there up to the time Mr. Nielas complained? And then what evidence of discrimination is there in support of his claim that his termination was discriminatory? And I think there's a key fact there, which is in between the time Mr. Nielas has complained about, or up until Mr. Nielas's first complaint, Mr. Saliani wasn't his direct supervisor. During the investigation into Mr. Nielas's complaint of discrimination, Mr. Saliani became responsible for Mr. Nielas, and then within a week or so, Mr. Nielas was terminated. So, to your question,
his claim is resting on conduct that occurred before that, before Mr. Saliani became his supervisor. And so I think you have two. I think that dividing up Justice Hanlon's questions into two questions is fine, but could you respond to the first question then?
Sure. And I think I've responded to the first question. The only evidence in the record as to Mr. Nielas's evidence of discrimination up to January 25th, 2018 is the ongoing pattern of embarrassing and humiliating treatment from Mr. Saliani.
What is that ongoing embarrassing, humiliating treatment? What are some of the, what is the evidence in the record of this ongoing treatment?
Sure, Your Honor. Certainly within the record is Mr. Nielas's complaint of January 25th, 2018. It's in the record at volume 2, page 142. But he describes a pattern of Mr. Saliani ignoring him and talking down to him and not working respectfully with him.
But nothing apart from, he must be doing this because I'm gay.
No, Your Honor.
In his head. All right. And in fact, Mr. Saliani worked remotely a good deal, right? They weren't like, you talk about somebody being openly gay in the office.
Well,
they're not in the same office, right? Oh, all the time.
40% of the time, Your Honor. So this isn't a situation where everyone works from home all the time. 40% of the time, 40% of the time they're together in the office. I don't think that's an insignificant amount of time to be spending in a relatively small office with two people. And you know.
All right, but even if we say there's a disputed issue whether he knew before the complaint was filed that the plaintiff is gay, you still need to offer some evidence that raises a reasonable inference that the termination was because he was gay and he's gay. And I'm struggling to see in this record how there's a genuine issue there for the jury.
Well, Your Honor, as to the circumstances of the termination, as to Mr. Nielas's claim of discrimination, which is separate from his claim of retaliation, as to your question, which I think is as to his claim of discrimination, it's that he's got a pattern of ongoing negative treatments. Mr. Saliani undisputably is aware that he's gay as of January 2018 when Mr. Nielas complains. Shortly thereafter, Mr. Soyani starts having responsibility for Mr. Nielas, and very shortly thereafter that he's terminated. I'll also turn your attention, Your Honor, within the record to plaintiff's evidence that the two openly gay employees were also the two lowest paid employees in the office. So as to the question,
they had different job titles and job responsibilities, right?
they had different job titles and job responsibilities from each other. Yes.
No, from the people who were paid more. Weren't the people who were paid more in management or executives or something like that?
Your Honor, I'm not sure that the record contains evidence of the specific differences between the two openly gay.
And they laid everybody else off, right? I mean,
well,
they were like the only two of the, they were 50% of the workforce, right? In the United States, right?
At the time of Mr. Nielas' termination, there had already been layoffs, yes. But
and in fact, laid off everybody but 4 people, and somebody was on contract, if I got that right?
Well,
and that's disputed. What Mr.
But Your Honor, the difference as to your question is there was a round of layoffs that took place prior to Mr. Soyani becoming Mr. Nielas' supervisor, and then there's a termination that takes place almost immediately after he becomes responsible for Mr. Nielas.
Okay,
So
but you're going to answer my question. Everybody,
Right.
Please, if you would. Everybody's laid off except for these 5 people, right? As of the time he was terminated, 100 people in Texas and some 20-something people in Boston have already been laid off, right?
Yes, Your Honor.
Okay. And given that, how can you reasonably argue that the reduction in force wasn't the real reason for his layoff?
Well, so Your Honor, then the question becomes the timing of the decision to terminate his employment. And that's a critical fact that the Superior Court got wrong. The Superior Court assessed that Mr. Nielas was terminated, or the decision to terminate Mr. Nielas took place before he engaged in protected activity. And that, Your Honor, is not supported by the record. The record, frankly, includes a number of the record includes a number of inconsistencies from Molecular Health as to when the decision to terminate Mr. Nielas' employment was made. At one point, it's made months before. At one point, it's made in early January. At one point, Michael Gaffar testifies that it was made 3 weeks before his termination, which isn't early January. It's actually the date he complained in January 25th. And Your Honor, the reason all of this is relevant is because where there's a dispute as to the when, there creates an inference of a dispute as to the why. If the decision to terminate hadn't actually been made before Mr. Nielas complained of discrimination, and there's reason to believe more than sufficient evidence to demonstrate that it wasn't, then the question becomes, well, why was he terminated? We know there's retaliatory animus. We know that the complaint was perceived as bad faith and as a last-ditch effort to save his job. And if Molecular Health's concern...
Yeah, okay, go ahead.
If Molecular Health's concern is that this is an employee who's desperate to save his job and is making bad faith complaints of discrimination, and then they decide they need to terminate his employment, that gives rise to an inference of retaliation, Your Honor. Because even though he might have been terminated eventually.
That statement about the complaint being made in bad faith, you're taking that from the MCAD position statement, right?
That's right.
That was made in the context of arguing that at the point that he made the complaint, he had already been told he was going to be laid off.
You're right, Your Honor. And that's a good question, because that's not that fact that you raised, which is at the time he made the complaint, he'd been told he was going to be laid off. That's not accurate. There isn't support for that in the record.
I thought
so.
Gaffar, is that however you pronounce it, said pretty consistently that the decision was made months before he filed the complaint.
Well, I think that goes to my earlier point that there are inconsistencies about when the decision was made. But if you're asking about the claim in the position statement that that plaintiff identifies as evidence of retaliatory animus, what it says in the position statement, this is page 93 of volume 3 of the record appendix, says the timing of Mr. Nielas' complaint after he was informed that he would be terminated shows that he did not complain of discrimination and harassment in good faith. Mr. Nielas wasn't informed that he was going to be terminated prior to January 25th, 2018. He was informed he was going to be terminated on February 14th, 2018, effective February 15th, 2018, the next day. So there's dispute on the record as to when the actual decision was made, but I don't think there's a dispute on the record as to the fact that Mr. Nielas wasn't informed he was going to be terminated at the time he initially complained about discrimination. And so,
Well, can we at least say, do you agree that your client certainly knew that the possibility of his job being terminated was a very realistic one? That was something that everybody was expecting.
certainly, Your Honor, I don't think that's in dispute by Mr. Nielas or in dispute in the record.
And
But
then
the-
eventually, within a year, everybody lost their job, right?
I'm not sure it's when I think at the time he was terminated, the company continued to exist for some not insignificant period of time in a real capacity. But
What do you mean by not insignificant period of time? Was it more than 18 months?
well, he was, I don't know if it was more than a year, but it was certainly more than a day, a week, a month.
With two people working remotely, right?
I think there was a hiring and at some point it became fully remote. But Your Honor, I think that those questions are relevant, but overlook the issue that if the termination occurred earlier than it otherwise would have, it's still unlawful retaliation. If Mr. Nielas was going to be terminated on April 14th, but then he complained about discrimination, they were concerned he was going to keep engaging in last-ditch efforts to save his job, potentially by going to the MCAD, and they expedited his termination, even if it was by a couple of months. That's still unlawful retaliation, and certainly there are cases within our briefs to that point.
What's your, all right, there is one case in your brief on that.
I think there are 5 cases in our brief on that, Your Honor. And so there might be an issue of what his damages might be if he was terminated on February 14th when he was actually just going to be terminated on March 14th. That's a fair question. But as to the question of, is it retaliation to terminate someone earlier than they otherwise would have been terminated? The answer is yes. That's unlawful retaliation. And there's a real.
When we're talking about damages, we really aren't talking about. My understanding was that the office was everyone was terminated. The office was basically eliminated within about a year or 18 months. But I will of course review that again. But certainly his damages would only extend to the period of time in which the office.
Yes, Your Honor.
Well,
And Your Honor, I think that's a better way of articulating the point I was trying to make. But it doesn't get to the issue of liability. Is there an unlawful retaliation if you do it earlier? The answer is yes. And what plaintiffs' briefs demonstrate is that there's no real evidence in the record whatsoever that Molecular Health made the decision that February 14th was going to be the day they notified him of his termination. There's certainly no documentary evidence to that effect whatsoever. There's inconsistent testimony to that effect, and there's a backdrop of circumstances that demonstrate that probably wasn't the case. On February 12th, they're saying, give us your goals for the upcoming year. That is not something an employer does if they've already made the decision weeks earlier to terminate him.
Unless they want to get the password from him and the other information that he has before they tell him.
Well, as to the password, perhaps, although he's told that they only need it in case of emergency. But scheduling a performance review for an employee and asking him his personal objectives for the upcoming year, I don't think is something that an employer does if they already know that 3 days later.
That was done by Celiani, who was his immediate supervisor.
Well,
so, I mean, it's not as though there's only one actor here, so right? So Celiani can proceed business as usual because he doesn't know that the plaintiff is going to be terminated, and there's management who's already made this decision. So
well,
sorry, go ahead.
Well, Your Honor, as to Mr. Celiani's involvement, or as Mr. Celiani making the decision, first of all, management is copied on the relevant email. Second, there remains a dispute as to the who is involved in the decision. And so, I understand trying to draw a distinguishing line between Mr. Celiani and management. Well, the answers to interrogatory say Celiani's the one who knows about the termination. That was subsequently.
The interrogatory was was framed and very broadly in terms of who has knowledge of the facts in the complaint. It wasn't who made the decision to terminate.
Well, Your Honor, our position would be that the individuals who made the decision to terminate would be the ones who have knowledge of the facts of the complaint, which alleges that the termination was unlawful. Your Honor, recognizing that my time has expired, I'll conclude unless there's something specific I can address for the court.
No, you're right, your time's expired, but I'm going to double check to see if there's any follow-up questions from the panel, and I see none. Thank you very much for your argument. And we'll hear now from Attorney Diamond.
Good morning, Your Honors. May it please the court, my name is Tracy Diamond, and I'm here for Appellate Molecular Health. I'd like to start with Mr. Ackerstein's comments about this concept of if Mr. Nielas had not made the complaint, he would have been terminated later than he was in fact terminated. There's no evidence in the record of any specific date later in time that he would have been terminated that was then accelerated up because of his complaint. As a matter of fact, the evidence goes the other direction. Once Mr. Nielas made his complaint, the company stopped their plans to pull the trigger on his termination and suspended that while they hired outside counsel to investigate the complaint. So if anything, his termination happened later than it otherwise would have happened because of his complaint, not earlier. And I want to kind of pull back to give this a little bit of context, because this is not a situation where, and Your Honors alluded to this before, but I just want to sort of like play that out a little bit in terms of this is not a situation where the appellant wasn't aware of what was coming. It was clear that he saw the writing on the walls here. There are several undisputed issues of material fact that are set forth in the 9A statement that discusses how as early as September, Mr. Nielas emails his supervisor, Mr. Sheridan, stating that there was a rumor that Molecular Health had only sufficient funding to last through January 2018. And then Mr. Nielas and Mr. Ducey, the VP of IT at the German parent company in Heidelberg, discussed whether the Boston office might be shut down. In statement number 49, the general understanding among the remaining employees was that the October 2017 layoffs, which laid off the majority of the staff in the Boston office as well as remote, that those layoffs were financially motivated and that Molecular Health wasn't doing well from a business perspective. On October 23rd, 2017, Mr. Nielas himself emails his boss and says, listen, I'd like a severance package with some monthly retention payments on top of my salary to keep me on board, because I'm not convinced that what you're telling me about the company doing well is actually what's happening here. And because the company's been, quote, doing nothing but layoffs since I started. And his request was rejected.
Was his layoff any different from everybody else's?
It was not. It was financially motivated.
But in the manner of it, the way that it was, the manner that he was laid off, what he was told, what the amount of timing, the severance, whatever.
Appellant makes the argument that the company hired outside counsel to prepare severance agreements for the October 2017 layoff ahead of time, and that they did not do so with Mr. Nielas, and that somehow is evidence that they didn't follow their own practices or policies. But the evidence shows, and the lower court addressed the situation in a footnote to the opinion, that the company gave Mr. Nielas a choice of going in two different directions with different monetary results, either to stay on board for an extra couple of weeks with a smaller severance at the end, or to be terminated immediately with a larger severance. So until they knew which direction Mr. Nielas wanted to go, they had held off on having the paperwork processed. So in that sense, there was an administrative difference, but in terms of the decision that was made and the reasons behind this decision, it was made, unfortunately, throughout this lengthy process of the company reducing and shrinking its US presence because of lack of business over a considerable period of time. And to go to Your Honor's questions about, what happened to the company after, Mr. Nielas is terminated effective February 15th. Mr. Goldberg, the office manager, is laid off in the second quarter of 2018 and was not replaced. By April 30th, 2018, Mr. Sheridan, the CFO, is no longer with the company. Mr. Saliani himself, the person who Mr. Nielas was complaining about, was laid off in early 2019 and was not replaced. And as of April 2019, where the record ends, Molecular Health had just 2 full-time employees and 1 part-time employee, all of whom worked remotely. There was no office presence at all. There simply just wasn't any justification for a $90,000 a year IT manager where there was no IT network left, unfortunately, in the United States. And
I mean, just say, where do you say we should look in the record for the timing of the decision to lay him off?
What do you mean by the timing of the decision?
When the decision was made
So yes, there's a couple of
on the
places in the record.
retaliation, so that we can look at the retaliation complaint.
I understand, Your Honor. There's a couple of different places, and just to highlight a few of them, in the second volume of the record at page 156, it's the email where Mr. Gaffar notifies Mr. Nielas of his termination and specifically states in the email that the company has since many more months forced to go through a painful restructuring process to account for lack of customers and business in the US. As a result, we see no viable option to continue your employment. And in the position statement before the MCAD, the company stated that it had significantly been reducing its operations in the US starting in October 2017, and that there was not enough work for the remaining few employees to justify employing a full-time IT manager. And then at volume 3 on page 20, there's some deposition testimony for Michael Gaffar, the general counsel, where he testifies as follows. Question, the company decided to separate the plaintiff from his employment? Answer, yes. Question, what was the reason for that? Answer, it was simply the result of economic reality. It was implementing the downsizing of operations driven by economic realities. Question, how long before that date did Molecular Health decide to separate him from his employment? Answer, as I said, many months before. It was obvious the company had no business. Mr. Nielas and Mr. Ducey, the VP of IT out in Germany, Mr. Ducey actually flew into the US to meet with Mr. Nielas in the days right before he made his discrimination complaint. And during that meeting is also very telling of the fact that this termination was imminent. Mr. Ducey asked Mr. Nielas for the master password. He asked for Mr. Nielas to put together some memos explaining how all the IT functions operate in the office. And there was some discussion about the fact that the small remaining staff in the US just didn't warrant having a US IT presence at that time. There's just no evidence here of pretext. You know, the legitimate business reason here is very strong. It's an unfortunate business reason for everybody involved, the company and the appellant, but nevertheless, it's an undisputed legitimate business reason that there just was not very many employees left at the time of Mr. Nielas's termination. And the lower court found that, viewed in the light most favorable to the plaintiff, the evidence didn't give rise to an inference that the stated reason for his termination was a pretext. While it is true that the complaint happened shortly before the termination took place, the decision happened prior to the complaint. And as I said before, the execution on that decision was.
Why is that not an issue, a jury issue? I mean, at least a disputed issue.
Well, because there's no facts that are in dispute. Mr. Gaffar's testimony says the decision was made many months before. Mr. Nielas has no facts to refute that that testimony. So it really is, you know.
Your brother says there are inconsistent statements about the timing.
Well, there's inconsistent, Mr. Ackerstein is pointing to inconsistent statements in terms of Mr. Gaffar not remembering the exact date that the decision was made to terminate, but that doesn't go against the fact that he said that it was many months before the actual termination took place. And it also it shows a very big consistency of the events leading up to what actually happened, as well as the justification for what actually happened. All sort of paint a very consistent picture of the fact that the termination was coming, Mr. Nielas knew it was coming, and even though he complained about Mr. Salyani in the past, he never once complained about discrimination until he believed he believed that he was about to get terminated. And that issue of good faith belief goes to the prima facie case for retaliation as well, because it is a prong of the prima facie case that the employee engaged in a good faith belief that he was being discriminated against when he made the complaint. And I would proffer that the complaint that he made was not in good faith. You know, Mr. Ackerstein admitted that it's not a winning argument that prior to January 25th complaint that there's any evidence that Mr. Salyani discriminated against.
What's your best case for the proposition that if it wasn't a good faith complaint, it's still retaliation if you move up the timing of the firing.
So Mole versus University of Massachusetts has some really good language about how disgruntled employees can't postpone their termination date by bringing a complaint. And if you give me 1 second, I can give you that quote.
I can get the case.
Okay.
Thanks.
In my remaining time, I'd like to talk a little bit about the Prima Facie case of discrimination. There's been this back and forth about Appellant claiming that he was openly gay and that therefore everybody in the office must have known his sexual orientation. That is not enough that is not evidence to refute the evidence of Mr. Saliani, that Mr. Saliani set forth in his deposition testimony that he did not know Mr. Nielas's sexual orientation, particularly coupled with Mr. Nielas's own deposition testimony that he did not ever speak to Mr. Saliani about his sexual orientation. Mr. Nielas points to some, he called them roundtable meetings where some of the employees meet, I think it was a lunchtime kind of thing, and discuss their personal life. But Mr. Saliani never participated in those meetings and in fact was only in the office 40% of the time. Mr. Saliani couldn't have discriminated against Mr. Nielas based on his sexual orientation if he didn't even know his sexual orientation at the time. I think that covers my argument. Unless your honors have any questions for me, I'd like to rest on my briefs and I ask that the appeal be dismissed.
Okay, let me just check with the panel and see if we have any additional follow-up questions, and I'm not seeing any from either judge. So thank you very much for your argument. Thank you both very much for your argument. The briefs are very helpful. The argument was even more so, and we will take the case under advisement and get an answer.
You're live.
Okay, thank you very much. And I believe it's still morning. It is. Good morning, everyone, and welcome to today's remote sitting of the Appeals Court. Let me begin by introducing the panel. My name is Ariane Vuono. I'm joined today by Justice Sydney Hanlon and Justice Suk-Young Shin. I would like to remind you of just two things, and that is that the regular rules apply to oral argument. Can you hear me okay? All right,
Yes.
I was just hearing a little bit of feedback, so I just wanted to be sure that we were checking. All right. The rules that apply to appellate argument as if we were in the courtroom apply also to a remote platform. So Attorney Bagnell, you have 15 minutes to present your argument, and Attorney Openshaw and Attorney Haskell are splitting their time 7.5 minutes each, and there is no rebuttal. Sometimes we have some technical difficulties, and if we do, we ask you to be patient. They're generally resolved very quickly, and no one will lose any time as a result of any problem that we may or may not have. So I'm now going to call the case, and one other reminder in this case, and that is, of course, the case is impounded, and so we expect that no one will use any names. All right. 2020-0689, Department of Children and Families versus Another and Father. Excuse me. Attorney Bagnell, please begin your argument. Oh, you're on mute. Start again. There you go.
Again. Good morning, Your Honor. May it please the court. My name is Carrie Bagnall, and I represent the appellant father in this matter. Father is asking this court to find that the trial court lacked subject matter jurisdiction to enter the judgment on July 19, 2019, permanently severing his relationship with his daughter. Alternatively, the father is asking this court to find that the juvenile court committed error of law in finding him unfit and permanently and forever severing his legal relationship with his young daughter. Lastly, father is asking this court to find that the trial court abused its discretion in not ordering post-termination visitation where there was a strong bond between father and daughter. There was no permanent placement for child at the time. The adoption plan was calling for recruitment of a pre-adoptive home. And most importantly, child herself at the conclusion of trial advocated for visitation up to 3 times per year. The jurisdiction argument, Your Honor, father is arguing that South Carolina, not Massachusetts, had jurisdiction to hear and resolve this case in July of 2019 under the South Carolina applicable law. Child was born in November of 2016. Child and mother left South Carolina in April of 2017. This case was filed 3 months later in July of 2017. Father argues at that time, child who was 8 months of age had been under the jurisdiction within the past 6 months of South Carolina law. So under South Carolina law, South Carolina had been the home state of child because she was born in South Carolina, was living in South Carolina for 5 consecutive months. Mother left South Carolina, came to Massachusetts in April, but this case in Massachusetts was only filed 3 months subsequent to that. And under South Carolina law, because child was, or under South Carolina jurisdictional law, because South Carolina was the home state of the child within 6 months preceding the commencement of this action, and father essentially lived in South Carolina. South Carolina was the proper forum jurisdiction to hear and resolve the custody issue, Your Honor.
Let me ask you this. If we were to disagree with you on your interpretation of the statute and disagree with the fact that South Carolina was the home state, are the facts that are within the record right now, the facts as found by the judge, because this issue was not raised before the judge, so it wasn't directly addressed, sufficient for us to make a decision?
I believe so, Your Honor. The facts that are pertinent here to your decision is when and where the child was born. So the child's born in South Carolina in November of 2016. There obviously is a footnote to that. Child's born actually in a Georgia hospital. However, for all intents and purposes, birth certificate, parents, child's born in South Carolina. I would suggest to the court that footnote is akin to Fall River residents in Massachusetts having their children at the Providence Women and Infant Center. They are Massachusetts residents for all intents and purposes. So child's born in a Georgia hospital, but in South Carolina, 2 parents living in South Carolina. Birth certificate is issued out of South Carolina in 2016. That is in the record. What is also in the record is that mother leaves South Carolina.
As does the father.
Okay, mother leaves South Carolina in April 17th, according to the facts, 2017, child's 5 months old. The facts are because the jurisdiction issue was not addressed, the facts are not absolutely clear as to why father left South Carolina.
But I thought you already indicated that we could rely on the facts as they've already been found by the judge to determine that. And there really is no dispute that he left and came to Massachusetts and stayed in Massachusetts. And so there was no parent left in South Carolina at that time in order to find.
I disagree with you in the interpretations of the facts. The facts are that the court found was that on June 17, father does leave South Carolina, that the intent of father's leaving South Carolina was to come up to Massachusetts to help mother procure housing. She was having difficulty procuring housing. Father does state
that he had father's testimony, but isn't the finding that he came to unify with the family?
He came to hopefully unify with the family. That is the finding, Your Honor. However, that does not occur. He never reunifies with the family. In June, now we're talking just days relatively speaking, somewhere between 14 and 20 days before the state.
Why does that make any difference? I mean, he came here, they couldn't find housing together because she could no longer be in a family shelter up in Lowell, the mother of the child. Then they stayed with a friend together in Fall River until such time as it turns out that that's not a safe place to stay. So why, on what basis are you saying that did not happen?
I'm not saying it didn't happen, Your Honor. I'm saying that I am arguing that it is not pertinent to the issue of jurisdiction.
Okay.
Because of the issues, because of the facts that occurs relatively quickly after that, which is father comes here, they're unable to get housing. Nowhere in the record does it indicate that father intended on staying in Massachusetts permanently. Father intended to reunify as a family. That is a
but that's not necessary, is it? I mean, at the time that the petition is filed, the entire family is in Massachusetts.
The entire family is in Massachusetts, and I'd say that what the record lacks as far as father is concerned is what was the intent at that time. Was it a temporary or was it a permanent move? The statute does.
And why is that important? Why do we have to determine what the intent is?
Because I'd argue that the statute allows for a temporary exit from the state that has jurisdiction. And certainly if two parents go on vacation, look at homes with a child.
But that's certainly not the case here. That's not the situation here.
The facts are father goes to Massachusetts to help mother with housing and to maybe become a family unit. And 3 weeks later, while they're searching for housing, Massachusetts state takes custody of the child. Father immediately.
So the question of whether Massachusetts has jurisdiction depends on what was in father's head when he decides to come to Massachusetts?
Well, not what was in his head, Your Honor, I would argue, but what his intent was at that, what his intent was.
How is that different from what it was in his head?
Well, intent would arguably include some evidence that, father may have intended to go to Massachusetts to live there permanently, but they couldn't. They could not achieve housing. And while they were trying to achieve housing in temporary shelters, the child was taken from their custody by the state of Massachusetts.
Why would he need to have the intent to live here permanently when the judge made a finding, which is undisputed, that he's been moving back and forth between Massachusetts and South Carolina since he was a child?
But
this is consistent with his pattern of moving back and forth. So at the time of the filing of the petition, he's back here. That's undisputed too. He stays here. He's here for the temporary custody hearing. He's here for he's incarcerated. And he remains here. So I don't see how his intent really could change anything, given the circumstances of his moving back and forth.
During the course of this proceeding, Your Honor, father did go back and forth between South Carolina and Massachusetts. Father attended most court hearings that he was able to. But I would suggest that too, undisputed with the court's findings, is that father had employment in South Carolina. Father had housing in South Carolina. Father had family in South Carolina.
He has family. Well. He has family here too, and he didn't move back and forth just during these proceedings. The finding is he's moved back and forth since he was 3 years old.
Yes, Your Honor, and we did not dispute that finding. However, during the course of the pendency of this case, father mostly resided in South Carolina, and all the factors that are pertinent to residence, employment, housing, even the service that father completed, Nurturing Fathers program, was done in South Carolina. So it is our contention that father's home jurisdiction was South Carolina. He was coming up for periods of time, 3 months at a time, to visit with his daughter and to contend with the court case. The issue, I guess this goes to, the issue of jurisdiction not being addressed at the onset of this case.
Well, it wasn't raised. So if we were to disagree with you and determine that the findings are sufficient to show that he lived here in Massachusetts, is it your position then that the facts are insufficient for us to determine whether the juvenile court had default jurisdiction, or are the facts sufficient for us to decide that question?
I would argue, Your Honor, with all due respect, that the facts are insufficient to determine whether or not the Massachusetts retained jurisdiction under 209B3, what we refer to as default jurisdiction, because our argument would be that South Carolina, on the facts, was this child's home state within 6 months preceding.
No, I'm not asking about that. So let's say we disagree that South Carolina had home state jurisdiction. Let's say we agree with the DCF and the child that there was no home state. The juvenile court could then exercise default jurisdiction, depending on whether there's significant connections to Massachusetts, substantial evidence. Are the findings sufficient for us to determine whether default jurisdiction existed?
I would argue the findings are sufficient, Your Honor, but I'd also argue that
sufficient? Okay.
Let me be clear, because I do think that you answered that question affirmatively earlier on in your argument. If I'm not, you do think that the findings are sufficient.
Well, the findings as they are, but the court's determination, but the court didn't make a determination. This court, I'd argue default jurisdiction should not have been exercised in this case, that it was not in the child's best interest, and that there weren't sufficient.
But again, but you do agree that we can make that determination based on the findings that have already been made?
No, Your Honor. I'll take that back. No. Because again, jurisdiction issue wasn't addressed. So we really don't have a clear understanding of what child's ties were to South Carolina. We know from the facts that child's ties to South Carolina included her father, her grandmother, her aunt, and that we can't conclude necessarily it would have been in the child's best interest for Massachusetts under default jurisdiction to retain jurisdiction rather than South Carolina.
Okay.
South Carolina being given the chance may have wanted to take this case. She was a resident up until moving in April of 2017 of South Carolina. And
that's really not the question. If we are assuming that South Carolina was not the home state, the question is whether there are significant enough connections to Massachusetts for the juvenile court to exercise default jurisdiction. And the judge, even though the jurisdictional question wasn't raised, did make findings that show that there are significant connections because mother grew up here, right? The reports were filed here, the 51A reports.
Parents met here.
Right. I think we can presume there's substantial evidence here. So I guess I'm asking, why aren't those findings sufficient for us to decide that question?
I would argue that they're not sufficient because the jurisdiction issue wasn't raised. My client wasn't given an opportunity to rebut those findings. The jurisdiction issue in this case was never raised during the pendency of this case. And as we know, it's preferred that when there is a jurisdiction issue, that the jurisdiction issue is promptly raised and addressed by the court so that we're not here doing what I'd suggest we're doing, which is, guessing and trying to fit the facts back into the puzzle piece. So
right. I think we understand your argument on jurisdiction, and it was very helpful. Thank you. And your time is up. I just want to assure you that nothing in your brief is waived. We will look at all of your arguments that you've raised and look at them very carefully. So we did spend most of our time on this one issue, but it was important. So I'm going to move now to the department and ask Attorney Haskell to begin his argument, which will go on for 7.5 minutes.
Thank you, Your Honor, and may it please the court. I suppose I'll begin with what seems to be the nub of this case, certainly the way we see it, and that is that the record contains everything that this court needs now, or that the juvenile court would have needed had the issue been raised to decide the jurisdictional issue. As the court, I think, is properly focusing its question and its attention. This goes to the issue of whether South Carolina was the child's home state as of the time the petition was filed in the juvenile court in July of 2017. It sounds like the father's counsel doesn't argue that that Carolina was the child's home state by virtue of clause little I of the statute, but rather we're looking at clause II, which concerns whether the South Carolina had been the child's home state within 3 months, and the child is absent from South Carolina because she had been removed by a person claiming to be a parent, and a parent or person acting as parent continues to reside in South Carolina. It's that last part where, in our view, the record evidence is sufficient. Obviously, as the court properly pointed out, the juvenile court found as fact that the father had moved from South Carolina to Massachusetts in June of 2017. And that's corroborated, it's well supported by the father's own testimony. There are 3 portions of the transcript that we would point the court's attention to, all in volume 1 of the transcript. The first is at page 120, where the father testified that he had initially come to Massachusetts in the late spring of 2017 to a visit and to help the mother find an apartment. The second portion of the transcript we would ask the court to focus its attention on is same volume, pages 154 and 155. And that's really the crucial part, because that's where the father testifies that while his intention was originally to visit, he later changed his mind, and he testifies to 2 points that are really crucial here. First, he says that he actually wants to live in the shelter with the mother and the child. As it turns out, he's not able to do that, but that indicates what his intention was at that time. And then he also testifies, you'll see this on page 155 of that same volume, that he intended to form a family unit with the mother and the child, while at the same time not re-engaging his romantic relationship with the mother. But those points are really the core of the issue for the court, and in our view, that's sufficient to sustain a finding that the juvenile court had jurisdiction as of July 2017. The last portion of the transcript that we would commend to the court's attention is, again, volume 1, pages 231 to 33, where the father speaks a little bit more about the timing and makes clear when exactly he came to Massachusetts. Unless there are any questions about their jurisdictional point, I will speak very briefly to the ineffective assistance of counsel point. This is kind of a funny case in the sense that the ineffective assistance issue is entirely subsidiary of the jurisdictional issue, in the sense that just the way the court has all the record evidence it needs to decide the jurisdictional issue, that also resolves the ineffective assistance issue. Because as we know from the criminal ineffective assistance of counsel cases that we cite in our brief, if the court can determine as a matter of law that the father was not prejudiced by his counsel's choices, then that's the end of the ineffective assistance inquiry. And on this record, the court has all of the record evidence that it needs to make the determination that jurisdiction was present, and therefore the father wasn't prejudiced by any choice his counsel made with respect to pursuing the jurisdictional issue. On the termination of rights issue and the post-termination visitation, I'm happy to answer questions. I'm also happy to stand on our brief on those points.
I'll check with the panel and see. I see no questions from either side. So thank you very much. Appreciate your argument. It's very helpful. And we can return now to the counsel for the child, Attorney Openshaw.
Good morning, and may it please the court. My name is Laura Openshaw, and I represent the child. This court should affirm in all respects the decree terminating the father's parental rights and freeing this child for adoption. To start, in the 2 years between the filing of the petition and the conclusion of the trial, this child knew stability. When she was not even 8 months old, she was placed with a foster family in Massachusetts, and she remained with that same family through the conclusion of the trial almost 2 years later. This family met her needs, her physical needs, her medical needs, her developmental needs, and her emotional needs. And she came to look to them for nurturing and for comfort. And that relationship that she had with her foster parents, her longtime foster parents, became at the time of trial her primary parent-child relationship, as adoption of veto would describe it. The father is unable to meet this child's need for stability. And the best evidence of this is his extremely inconsistent visitation with her over those 2 years. And there were 2 separate 6-month periods where he did not see her at all. There was a separate—
Were those periods when he was in Massachusetts or when he was in South Carolina?
The 2 6-month periods he was in South Carolina, there was an additional 3-month period where he was physically present in Massachusetts and didn't see her at all. And the quality of those visits was also variable. The record indicates that there were several visits where he was warm and playful, and that she responded with affection. There were also times when he needed redirection, and that she shied away from him, didn't engage with him, or tried to leave the room. When his extreme inconsistency with visits with the child is seen together with DCF's with his minimal engagement with the department and his minimal engagement in services, it's clear that that these were factors that the trial court was entitled to consider in evaluating his fitness and her best interests. And in fact, under 210 Section 3, subsections 3 and 10, the trial court was required to consider those factors. Additionally, in evaluating his unfitness, the juvenile court properly considered evidence of the father's struggles, both continuing and historical, with mental health issues, his transient lifestyle, where from a very young age he had moved from Massachusetts to South Carolina and back and forth, and that his struggles with mental health had made it difficult for him and to maintain steady employment. And this is something that he acknowledged to the department. He testified at trial that his issues with depression were continuing. And he also testified at trial that he had struggled with paranoia, and he himself connected those struggles with paranoia to his decision to possess firearms, which, as his lengthy, serious criminal record indicates.
That was a long time ago, though, right? That was 2010.
I believe his most recent conviction was some years before the trial, although there's no evidence to suggest that he had engaged in any sort of treatment or any sort of services that remedied the issues that would have led him to make those choices. And in any event, his inability to hold employment, to stay in one place, and most of all, his difficulties with maintaining contact with his child, whether he was in state or not, were evidence that the trial court properly considered in finding that he was unable to meet this child's need for stability. Addressing the point as to just the jurisdictional issues in the case, I would agree that the trial court's findings, none of which father contests as being clearly erroneous, would lead to the conclusion that the juvenile court properly exercised default jurisdiction under Section 2A2 of the MCCJA. In addition to the transcript sites provided by the department's counsel, I'd also point the panel's attention to page 39 of the second volume of the record appendix. This was a portion of the 51B investigation report, which ultimately, in the course of which, led to the child's removal. And at that time, before the child was removed, while they were staying, I believe, shortly after the family had left the shelter, while they were staying with father's friend, the father himself told the investigator that he was in Massachusetts to be a family unit with the mother and the child. And we see from his actions the fact that he remained in Massachusetts, didn't immediately return to South Carolina before or after his period of being detained, that was his intention to stay in Massachusetts and not to immediately return when. Additionally, I would ask the court, in terms of looking at the child's home state, and the father's relocation back and forth, that the section 1 of 209B, the definition of home state does look to the child's temporary absence from the Commonwealth that section of the statute indicates that temporary periods of absence they count towards these periods. It does not make the same, it does not cover the father. So if the father is temporarily absent from South Carolina, we look not to whether it's a period of temporary absence, we look to what his intentions were as he declared them to be at the time, as he expressed that they were at the trial, and also how his actions were consistent with those stated intentions.
Let me ask you, if I may, briefly, before your time is up, about the issue of visitation, about the decision on the judge not to order any visitation, especially given the fact that one of the potential avenues for adoption was a return to South Carolina. And some of the visits, as you've indicated, were positive ones. Others were not, but some were.
Yes, it is true that at the time of the time of closing arguments, child's trial counsel did suggest some amount of post-termination visitation. Child did not file a notice of appeal as to this issue, and child's position has since changed in light of the changes of circumstances. And this court is able to affirm the denial of the trial court's decision not to order post-termination and post-adoption visits, notwithstanding the child's change of position. And in this case, where the father was extremely inconsistent with his contact with the child, where she was inconsistent in her responses to him, and where she had been placed with the same foster family for 2 years, and where there was evidence in the record that, as we see in Vito, that relationship with her foster parents was her primary parent-child relationship. The judge was in their discretion to not issue that order. And in fact, the judge deciding not to issue that order did not order that there would be no contact. It's the judge merely declined to set a floor of number of visits, and it is within the adoptive parent's discretion that to allow or not allow visitation as may be in the child's best interest at that time.
Okay, thank you. I'm going to check with the panel to see if anyone has any follow-up questions for you, and I see that they do not, and your time is up. I want to thank all three of you very much. These cases are always very difficult. We know that, and we know that's also hard to cover all the topics during one oral argument. But again, as indicated to you before, attorney, that we will take all the issues and all the arguments under advisement, and we'll get an answer back to you as soon as we possibly can.
We are live.
Okay, thank you very much, and good afternoon, and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono. I'm joined today by Justice Sidney Hanlon and Justice Suk-Young Shin. Before I call the case officially, I want to remind you of two things, and that is that the rules that apply to appellate procedure and particularly oral argument that would be in force if we were in the courtroom are exactly the same with respect to having argument on this remote platform. So each side has 15, I remind you that each side has 15 minutes and there is no rebuttal. And second, I want to let you know that upon occasion, and so far today, I don't want to jinx it, we've had no problems whatsoever, but upon occasion, we do have some technical difficulties. And if that happens, just be patient. They generally are resolved quite quickly. And I can assure both of you that neither one of you will lose any of your allotted time for your argument. So that said, I'm going to call our last case of the day, which is 2020-0685, the town of Ware versus GLEN, DESJARDINS, and others, represented by Attorney Bradford, Attorney Martin, correct? One moment, you're on mute.
Good morning, Your Honor. I represent the appellant, Hull Forest Lands, LP.
Oh, okay, all right, thank you.
Attorney Bradford Martin representing them. The crux of our appeal has to do with the fact that it's our contention that the judgment in this case that resulted from a tax taking was void. Void for a couple of reasons. The first reason was that there was no evidence that the assessed parcel that the town of Ware assessed to owners unknown ever existed. Not that they just couldn't find the owner of the property, but there is nothing of record to suggest that that parcel as a legal parcel ever existed. And we believe the record had evidence to support that. Secondly, it's void because the application of the town to assess to owners unknown should have been reversed by the town once they became aware that there was a party, number one, claiming ownership, which Mr. Hull did on multiple occasions in writing and in person, and also that he claimed he was in possession and demonstrated acts of possession, and having evidence that the town should have then done their due diligence to determine that.
Counsel, sorry to interrupt. But what authority authorizes vacator of the judgment based on voidness?
I believe Rule 30b-4 provides.
Okay. I mean, as a general principle, the rules of civil procedure would allow a motion to vacate based on voidness. But I mean, in this specific context, it seems that the statute is very clear that the motion has to be brought within 1 year. And then the SJC case law is very clear. Once you're past that 1 year, the only basis on which you can vacate a judgment is a denial of due process.
Yes, and there is case law that supports that with respect to substantive due process cases, that there is no real time limit as it relates to that, where there is a deprivation of property and there's no adequate justification for doing it. In this,
what is the substantive due process violation here?
well, there was a deprivation of property. This property was claimed to be owned and by Mr. Hull, and he provided evidence, at least some evidence as it relates to that. And it was taken for a tax bill of $330.
After due process. I mean, that's, if it was taken in deprivation of procedural due process, that would be a different question, but it's not a substantive due process issue.
Well, our position is that the taking, the assessment was void ab initio. It could not have stood because the town assessed a piece of property that simply did not exist as a matter of record.
Well, that's a little bit, if you can maybe illuminate that point for me. I mean, the property exists, the land is there.
Correct.
And it's described as a parcel by the town, correct?
Correct.
Okay. And then that parcel is taxed.
Correct.
Right. And no one pays the taxes.
True.
So how can you explain to me how it is that you say that the parcel doesn't exist in the first place?
Because there is no deed of record to the property at any time in any form. There is no plan of record that describes the property in any form. There are no references to this property of any kind, of any nature.
Including in your client, I mean, what did your client, you say that your client walked the land, right? Did he, are there descriptions in what he bought from the woman, and did he pay taxes on it?
Mr. Hall purchased an adjacent piece of property, which in his legal description was described as 125 acres.
And would that 125 acres necessarily include the property at issue, or did he have 125 separately?
All I can say is that the survey that he ultimately did showed him to own 155 acres, which would suggest that the 30-acre parcel that was
the survey after the one after the first surveyor said he wasn't gonna, he couldn't, it wasn't part of the same process, and then they talked to the lawyer and they got another one. That survey, right?
There was only one surveyor, and that was in the course of discussions regarding the property and the legal description. So there was only one surveyor.
He bought 125 acres, and when that surveyor got done, after, like I said, on the second try, right?
Correct.
It turns out he's got an extra 30 acres or so.
Yes. From what his deed described.
And is that the size of the property at issue?
The size of the property at issue is almost 34 acres, 33.97 acres. And when that survey is seen, it has all of the proper evidence of boundary lines. It refers to monuments. It refers to stone piles, stone walls. It has all of the normal boundary requirements that are used to create a legal description. The town or the appellees produced no evidence that this property ever existed as a separate, distinct legal property. The town does not have the right to create one. And once they knew that Mr. Hull claimed ownership, they then needed to take steps to make a
Why? They had a judgment at that point.
But their judgment was void because
someone has to bring that. Someone has to attack the judgment in order to make that you to draw that conclusion.
Well,
which Mr. Hull did not do.
They filed a motion to vacate the judgment, and the basis for the vacating of the judgment was that that property didn't exist, and there was testimony by a land court title examiner that said that parcel, as assessed by the town, simply did not exist as a matter of record.
All right, even if we assume there was an error in assessing this parcel separately, let's just assume you're correct. Do you have any case that says that this is a due process issue?
I don't have a specific case that says it's a due process issue.
Okay.
Then the fact, well, I have two cases that talked about how there is no time limit. It's to 60B4 cases because a void judgment can never acquire validity.
So then the statute loses meaning then? The statute says the motion has to be brought within 1 year, right?
True. But
so how can the rule trump the statute?
Well, the statute has to assume that the judgment isn't void in the first place. That
Why?
It's some basis. I mean,
why? I mean, the cases are very clear. I mean, as recently as last year, the SJC said once the year has passed, the only basis on which you can vacate a judgment of this kind is by showing a violation of due process. I mean, it seems crystal clear to me. I don't know how we would even be able to get around that.
Well, I believe that the the 1 year simply doesn't apply to it cannot apply as a matter of law with respect to a judgment which is void ab initio.
But is there no time limit on waiver? I mean, I understand if your client just found out, but it's been 10 years, right? I mean, you had the judgment, he knew they took it back. He's never filed anything until after these people bought it at auction, right?
That's correct. Well,
so there's no latches, no waiver, no nothing. He could wait another 20 years and not offer to pay taxes or anything else in the meantime, right?
Well, I mean, he thought that he should pay taxes because he thought he was the proper owner of the property, and he put the town on notice that he was. They took no action at all.
He didn't ever tender back taxes, from what I understand. Isn't that undisputed? He never offered to tender the back taxes at any point.
I don't believe that he did, but that's because he believed that this parcel of land was part of what he already owned and what he had already paid taxes on.
But he didn't contest the tax assessment in that respect, right? In other words, you're saying that his point was, I'm already paying taxes on this 120 acre, and you're trying to give me an extra bill, but he never challenged that assessment.
He didn't, and he said exactly that in his letters to the town.
Okay, but that's not the way one would challenge an assessment, right?
Understood, but when he first wrote to the town in 2008, when the first auction was imminent, they stopped the auction and took no action at all and never communicated with him again. So it was not unreasonable for him to assume that the argument he had made to the town convinced them that he was in fact the owner and that he was paying taxes on his entire parcel.
And also apparently that was sufficient in your view for him to assume that the town did not want him to pay any of the back taxes?
They never communicated to him in any way about whether or not his property should be reassessed. I mean, the irony of this is you have a town saying, we don't know who owns this property. We don't even know if it exists. We've got no basis of the record. And somebody shows up and says, guess what? I own it. Why at that point wouldn't the town have simply said, fine, thank you very much. You say that's his due diligence. You're the logical person as an abutter. We will reassess your property. And oh, by the way, here's your new tax bill. At that point, he could have contested the fact that he thought he was already paying the taxes or not. But the town, having declared that this property was owner unknown, was faced with the fact that there was an owner who was making representation.
But the town's decision that it was owner unknown was not just something that was made out of cheesecloth. In other words, they had, of course, they'd gone to DOR. They had their own independent surveyors. That the land court was involved. I mean, there was some investigation with respect to that. No.
True, but they then were faced with an owner, a purported
someone
owner.
Who claimed to be an owner.
Yeah.
I think he said, did he say, I think I own this property or something along those lines?
I think it was more definite than that, Your Honor, actually.
All right. Well, we can look at the record again.
He did it 3 times, and but he displayed all the indices of possession too, which is also a reason why property can't be assessed to owners unknown.
Well, thank you very much for your argument. I'm just going to check with the panel to see if they have follow-up questions for you, and I see none. So we're going to turn now to Attorney O'Hara, who represents the town of Ware.
Good afternoon, Your Honors. May it please the court, Ryan O'Hara of Bacon Wilson on behalf of the plaintiff interveners appellee. There are two compelling reasons for this court to affirm Judge Long's comprehensive decision denying Hull's motion to vacate judgment. However, before turning to those, I do briefly want to address the issue of this survey that's been referred to that purportedly depicts Hull's ownership of this property. To be abundantly clear for the record, that survey never was admitted into evidence at trial for the substantive truth as depicting any ownership. If you turn to pages 217 to 218 of the record appendix, you'll observe a colloquy with the judge when that plan was admitted, and the judge expressly states that it is not being admitted for its truth, but rather only for, quote, a limited purpose, just a copy of a survey put on record. So when considering the role of the survey, the plan, or anything in this matter, it can solely be considered and was solely considered by Judge Long for the purpose of showing that Hull had a survey performed, but not that Hull had confirmed ownership. And in fact, as set forth in our brief extensively at footnote 19, which is on page 30 of the brief, Hull never introduced any evidence at trial whatsoever that it in fact owned the property, which is an issue the judge chose not to reach because he did not and need not reach it, and that's at page 46 of the record appendix in his decision. However, there is no evidence of ownership. So then turning to the substantive points, first and foremost, Judge Long correctly found that Hull's nearly 8-year delay in bringing its motion after learning of the taking and the adverse claims of the town as to his own bare belief that he owned this property was unreasonable, barring relief. As Judges Hanlon and Shin have correctly observed already today, the issue of waiver in Massachusetts case law on that point is absolutely clear that this issue is conclusive as to the entire appeal, regardless of whatever issues might exist with due process, regardless of any other arguments made by the appellant. And tellingly, until the very close of oral argument today, the appellant has never confronted the issue of delay in its papers, even though that issue of delay was the foundation when looking at the Judge Long's decision holistically for his decision. At pages 50 to 51 of the record appendix, it's a portion of Judge Long's decision analyzing this issue. And I raise it only to point out that he pervasively relies on Sherwood Forest, which was a case decided by this court on appeal from a decision authored by Chief Justice Green when he was a judge of the land court. And that case stands for the proposition that motions for relief from judgments foreclosing a right of redemption in tax-taking cases must be brought within 1 year, absent due process issues. And even where a due process violation has given someone standing to bring a motion outside of that 1 year period, even then, if there's unexplained delay in a person sitting on their rights and doing nothing to pursue those rights, after getting actual knowledge of the taking, which under Massachusetts case law cures any notice issues, any substantive or procedural due process violations to that point, there is an affirmative obligation to do something to move that forward. And here's where it's instructive, I think, to look at the facts of this case as to what happened here. Undisputed, at trial or on appeal, that Hull learned in 2008 that 1, Hull claimed an absolute right to this property, and 2, the town also claimed an absolute right based on a judgment that had entered 2 years prior to this property and intended to sell it. At that time, when Hull came forward and indicated that he claimed to own the property with no proof, which to that point Hull had none, having only ever walked the land when purchasing the property, performed no title search, never had a survey performed prior to purchase or prior to learning of the taking. At that point, the town did cease its efforts to sell the property. However, in no way did it communicate to Hull that that was a concession of his ownership, and in no way did Hull seek to act consistently as though it were a concession of his ownership. As Judge Hanlon's observed, Hull made no effort to ascertain what the back taxes were, to offer to pay those taxes, to ascertain what current taxes would be assessed if he did, in fact, as he believed, own the property, or pay those taxes that would then be currently accruing. By Hull's own admission, it did nothing for 5 years between 2008 and 2013, when the town, relying on its absolute title established by Chapter 60, Section 64, then again listed the property for auction. Mr. Hull and Hull was notified as abutters to that proceeding, and they in fact appeared at the auction that was held in 2013 and placed a bid. And at that auction, my clients ultimately purchased the property. So at that point, having done nothing between 2008 and 2013, Hull then came and observed the town sell the property to other individuals. Now, if at that point, somehow, Hull believed that he owned the property, which Judge Long expressly found would not have been reasonable, but even then, at the point the town sells it to innocent third-party purchasers, any person, set aside someone of Hull's sophistication who owns 28,000 acres of property in the United States, 28,000 acres, setting aside that experience, any person, after seeing the town sell what you claim to be your land to another person, would know that there's a dispute as to title. Even at that point, Hull waited another 2 years before, for the first time, doing anything to vindicate its property rights when it first attempted to have a survey performed. As has already been pointed out, the original results of that survey indicated that Hull did not own the subject property at issue, but ultimately a survey was prepared that appeared and purported to reflect his ownership, which again was never admissible at trial, nor was any other evidence of ownership. And then, even with the plan in hand, Hull waited yet another year before filing the motion to vacate judgment, meaning that between when Hull observed personally the property be sold to third parties, it waited a total of almost 3 years to bring its motion to vacate judgment from that date, a motion that, if ultimately successful, would divest those third-party purchasers of what they had bought 3 years ago. Now, equity is not a consideration in delay because the case law under Sherwood Forest, Vincent Realty, the Andover decision, all of which are cited extensively in our brief at pages 21 to 23, makes very clear that delay alone, regardless of any equities, is sufficient to deny motions to vacate judgments foreclosing tax lien redemptions. And the reason for that is the bedrock public policy established by the legislature in tax-taking foreclosure proceedings and their finality. Chapter 60, sections 53 through 66 and 69A exhaustively set out that these judgments in tax foreclosure cases are final and cannot be set aside for any reason after a year. So with that policy of finality, it's there to protect the interests of the towns in getting some speedy resolution and finality in the decision so that the towns can then resell the property, get it back on the tax roll, and finality to protect any third-party purchasers to whom that property is sold. So here, those equitable considerations actually do come to the fore. But given the length of time which Judge Long so heavily relied on, almost 8 years between the first actual knowledge of this taking and the redemption foreclosure and the filing of a motion to vacate, Judge Long found that under any circumstances, that is an unreasonable amount of time for a property owner to wait to pursue their motion, and it should be precluded. I would only point out on this point, unless there are further questions, that Judge Green in his land court decision in Sherwood Forest aptly analyzed this whole statutory regime and made an excellent point that is, in the ordinary course, where someone gets the absolute best notice possible, you have a known owner who's aware of the foreclosure proceedings, and then a judgment enters, that person has 1 year under any circumstances to bring their motion to vacate. And Judge Green observed, and I would say that this observation carries through throughout all the case law, regardless of who's written it, and is definitely a significant component of Judge Long's own decision here, that people who have had due process violations, but at some point get actual notice, there's no reason within the statutory scheme that those individuals should be given more time than other owners who got an actual notice, which is 1 year from that actual notice. And here that was exceeded by 8 times. 8 times. Judge Long firmly and properly exercised his discretion in applying these very clearly established factors to undisputed facts in finding that Hull was not entitled to the extraordinary relief it was requesting, which the case law is clear should only be granted where required to accomplish justice. And I would suggest the strength of Judge Long's finding on that issue is the exact reason that the appellant never even addressed it in their brief here and never even addressed it until directly asked in argument. And there is not a common citation, even to the tax redemption foreclosure statute, between Judge Long's decision and the appellant's brief. Now, if there are no further questions on the length of delay and its preclusive effect, I would move to the due process issue, which, given the delay issue, this court need not reach because it is subsumed within the delay issue. However, Judge Long was also absolutely correct in exercising his discretion to decide that there was no due process violation here. First, Judge Long correctly identified that the issue of due process in these cases is issue in the notice and procedural due process of the foreclosure proceedings themselves. And all the record evidence here, which was never rebutted, not even by credible evidence, but no evidence whatsoever, was that from 1997, when the town initiated its tax foreclosure proceedings, it took every single appropriate step, performing its own title search, going to the DOR for authorization, performing another title search, then the land court examiner examining and the judge approving the land court examiner's authorization in finding that there were no record owners of this property. Then notice by publication, which is expressly authorized in these cases under statute, that would be chapter 60, section 66, was issued. And nobody came forward and responded, at which point the judge reviewed all of this and entered judgment foreclosing the right of redemption. That is clearly the process that's due in circumstances of owner unknown, as set forth by the Supreme Court in its decision in Flowers and by this court in its decision in the Boston v. James case. Publication in cases where all reasonably diligent efforts have failed to turn up a more efficacious way of service is sufficient due process. The only cases that I have reviewed where a due process violation was found, giving standing outside of that 1 year period, are, for instance, the Supreme Court's decision in Covey, where the individual against whom proceedings were going forward was known to town officials to be adjudicated incompetent, or at least perhaps just incompetent, and without a guardian. And nonetheless, they notified that person. That was a due process violation. Similarly, in the James case, the city had actual knowledge and leads that the person who was the property owner was living elsewhere and took no affirmative steps whatsoever to find or serve that person, mailing things only to the property they knew to be vacant. That was a due process violation. What none of the cases suggest to be a due process violation is the original act of the assessors in designating a parcel for separate assessment and then proceeding in compliance and good faith with all statutory requirements to in fact assess those taxes and then collect them. There is nothing to suggest that. And I would suggest that that argument, which only was raised for the first time in the appellant's closing argument at trial, there was no evidence at trial introduced on that point, and it's not raised in their original motion. Not raised as a basis in their original motion. That's been waived. But to the extent it hasn't been waived, it's putting the cart before the horse. Because the purpose of the motion that the appellant brought was to collaterally attack at that point, 10-year-old judgment. And to prevail on attacking a judgment, whether in a tax-taking case or otherwise, it's an examination of the judge's discretion in choosing to vacate the motion or not that controls. And if the judge sets aside the judgment, then substantive issues as the propriety of the assessment of the taxes, the amount of the taxes, the propriety of interest that's been collected on the taxes, all of those are available in the case in chief. But on the motion to vacate judgment, the substantive grounds that the moving party intends to argue if they prevail on the motion to set aside judgment do not themselves become reasons to set aside the judgment. And if the court does not have any further questions, I would rest on our brief, seeing my time is short.
About 1 second. So yes, you're right. I'm going to check with the panel to see if anyone has follow-up questions. No, thank you very much. The arguments were very helpful. I want to apologize to Attorney O'Hara that I indicated you represented the town of Ware when of course you represent the interveners, and so I apologize for that. Thank you both very much. We will take the case under advisement. We will get back to you as soon as possible with the decision in this matter. And I think that's our last case for the day. So I think that the court can now be is no longer in session. Thank you.